Supplementary list for judgment, item 66, writ appeal 9 of 18.
The judgment rendered, impugned judgment rendered by the learned single judge does not suffer from any infirmity warranting interference, hence the writ appeal fails. The respondent shall be appointed as a constable in the appropriate category as per the marks obtained by him, subject to his clearing the physical efficiency test. Notional benefits from the date of appointment of the last candidate.
I think item number 10, my lord. The appellant has filed the additional affidavit yesterday. Now we are for the respondent number 6, the private respondent. This is regarding the appointment of principal of Tukraja College. Some time to file a reply.
Reply,
My lord.
non-counsel appearing for the reply would be that opportunities to the appellant.
Additional affidavit we have filed, Lordship. We
You have filed an additional affidavit.
additional affidavit.
An additional affidavit has been filed on behalf of the writ appellant. Non-counsel for the respondent prays for time to submit a reply thereto. 3 weeks time is granted for doing the needful list after 3 weeks.
Published.
Lordship, can it be 2 weeks, your Lordship, if it is not inconvenient, Lordship?
2 weeks, otherwise also 2 weeks now it is
Lordship,
going to
it will
come up
be
in
inconvenient.
October.
Then it's okay, Lordship, no issues, no. Much of it.
May it please your lordship. My lord, with the consent of from the other party, my lord, I beg to mention item number 18 today's list.
18.
My lord, my lord. I've taken the consent from the other parties. It may be,
Additional
Lordship.
Advocate General, MS so and so, appearing for the state of Nagaland appellant, has circulated an adjournment slip. This court is informed that the other side has no objection to the prayer for adjournment, hence
my
re-notify
lord, if it can be placed on the 5th of October, my
on 5th October as
Lordship.
prayed.
obliged.
Daily list for orders, item 4.
Made to the Look, this was the revival of the original case, my lord.
Mr. Nath was supposed to
Yes, my lord.
give his response.
Here, my lord, I have received some instructions, my lord. My lord, my instruction says that the earlier committee could not submit the report. Now a fresh committee has been constituted and the committee has been given some time to submit the report.
File it in record.
Lordship, I'll
It's
file,
not placed for
Lordship. 3
for
weeks
the
I-
time of 3 weeks to place
Lordship,
the response of the respondent authorities
Lordship,
on record.
my lord, full file, my lord.
Re-notify on 5th October.
Obliged, lordship.
Deeply.
Item number 5.
Delay condonation.
My lord, 57 days, my lord, last occasion. I have pressed this honorable court that after obtaining the order, we have pursued the matter to the higher authority. But the opposite party raised an objection that we have obtained a certified copy after the limitation period. And this honorable court directed me to file a reply annexing all documents that we have taken a initiative pursuant to the order, my lord. And therefore, I file a reply, my lord. Reply
What is the date of the impugned order?
26, 2020,
26.
20th June,
20 is June, yes, Lord.
20th June. And when did you apply the copy?
And-
After the limitation period is over, Lordship.
57 days. My lord, I have annexed all these things to substantiate the fact that we have taken initiative.
If you don't file even an copying application
My lord,
within the limitation period, how your steps can be said to be
my
justified?
lord, the post, the officials of the post has no authority to prepare an appeal until and unless it is approved by the ministry, my
We
lord.
understand, but the counsel who appears for the applicant, he is supposed to obtain a copy in time. Is it correct or not? When did you file the
My lord,
copying application?
We did not wait for the certified copy, my lord. I have annexed it, my lord.
Let us see.
After obtaining the order in the website, my lord, we forwarded this annexure C at page 49, my lord, of my.
So you moved the proceedings for filing of appeal even before receiving the copy?
49, my lord.
Yes, yes.
Yes, this is the letter to the law directorate, my lord, from
Yes,
NES.
madam, they have started the proceedings even before getting the copy. That is bona fide action. Then ultimately approval comes in. That
No,
takes
Lordship,
time.
Actually, appeal is required to file within 30 days. And
We understand.
delay in question arises from the lapse of the 30 days.
Yes.
In reply, they try to explain the delays within the prescribed period of 30 days.
Yes,
Not-
yes.
They should explain the 30 days beyond the lapse of the judgment.
What more expediency do you want? That even before getting the copy, they downloaded it. Now, as a matter of fact, this certified copy business will become redundant in times to come. You download a copy and that is a certified copy. So there will be e-signature. Now they have started, as he has filed the documents, the process was started immediately for filing the appeal. We'll hear you on merits. I think that's better. Delay Karnoon,
Lordship, kindly fix a short date for hearing.
Delay Karnoon list for admission after 2 weeks. I'll, Gunajit, few grounds will have to be mentioned. Sure. Okay.
Item number 6.
Sanitary. Mentioning the contents of that reply. Page 49 and the government's in the reply. Objection as well as reply. Yes.
Lordship, contempt petition, Lordship preferred against the non-compliance of the order dated 13/9/2000.
What is the order, Ms. Counsel?
Lordship, operative portion of the order, Lordship kindly have a look at page 17. Para 10.
So the Deputy
Yeah.
Commissioner was directed to consider your representation.
Lot.
It has not been done.
That-
Heard, issue notice to the respondent. Steps for service be taken within 3 days. Whereafter process be issued. Rule is made returnable in 4 weeks thereafter.
Item number 7.
May I please? Lordship? This is for non-compliance of the order, Lordship, that operative part of the order is page 22, Lordship. Second last paragraph, Lordship.
So this was covered by the other judgment.
Other judgment, I have annexed that also.
What happened in that case also? The appeal was dismissed.
Appeal is allowed, lordship, directing the authorities to pay arrears.
Appeal was allowed.
Allowed, lordship, in the light of that appeal, lordship.
Okay,
This is
okay. Heard, issue notice to the respondent. Rule is made, steps for service be taken in 3 days, whereafter process be issued. Rule is made returnable in 4 weeks.
Item number 8 and 9.
By the order dated 9th of June, my lord, there is an order for producing the original contract, last contract.
Yes, you have the original contract.
My lord, in item number 9, we have the original contract. In 8, it is still awaiting, my lord.
Why, how much time will you need? We have given you ample opportunities.
Yes, my lord. My lord, last opportunity.
From June, my lord, it is 9th of June.
All right, Land Council for the Panchayati Raj Department.
Yes, my lord.
My lord, may I submit one thing, my lord? The same, my lord, contract in the item number 9, same contract, my lord, same terms and conditions.
Let us have it. We'll give him one more opportunity. Raise for is granted. One for more opportunity of 10 days to keep the original contracts available. Re-notify on 27th September.
Obliged.
Item number 11.
Yes.
Right, your lordship. The petitioner before your lordship is an employee of the bank.
Removal from service. We'll admit the appeal.
My lord,
Irritated. We'll admit the appeal.
otherwise, the honorable single judge has already relegated the matter to the labor court to decide the issue. My lord, the award was passed.
We are not staying that direction.
Yes, yes. And we have already submitted our written statement there.
Admit issue notice. The respondents are duly represented. Thus, process need not be issued.
Highly blessed.
Pray for stay of the hearing.
Let the proceedings go on. What is the problem?
My lord. Highly blessed.
Item number 12.
My lord, I pray for 1 week's time to obtain some instruction, my lord. It's regarding the effect of Uma Devi.
Mr.
Lord.
Pukan appearing for the appellant university. Raised for and is granted.
I'm for Respondent 1, madam.
Granted 2 weeks time to complete his instructions.
My lord. Most of them. Not the record, my lord, the record may be called for, my lord.
What record?
My lord, that, my learned friend has not annexed that, my lord, that the relevant record, my lord, petition and others, my lord. It's not about the record, it's about the effect of that constitution bench, the judgment rendered in Uma Devi. So, my lord,
You file whatever you want to file, you
Yes.
file it. Or we'll call the file as and when required to.
yes,
It's
Most
in
of-
records of this court only.
most of them.
Item number 13 to 15.
We have seen the judgment, lordship.
In light of Fortune Manage
Yes, lordship.
rejected in light of so and so.
Lordship directed me to prepare the short notes.
Please give it.
So I prepared for 3 days, separate one, because the questions are different, you know, so.
Okay, then all right, we'll reserve the judgment and then
Comparison is not,
judgment reserve. Heard judgment reserve.
not much of. Comparison.
Item number 16.
Lordship,
Hmm.
like lordship, 2 weeks time may be granted for filing of affidavit, lordship. We had to seek further instructions regarding the proceedings.
Same officer. Yeah, those pictures. I think this is same, same man. Okay. And counsel for the respondents has circulated an adjournment slip. The counsel representing the appellant is marked no objection thereupon. List after 4 weeks as read.
Much obliged.
Item number 17.
Lordship, let the matter be passed over for the time being. My senior counsel, she will be here in few minutes.
Pass.
Here, my lord, we are required to file the affidavit, my lord. On my personal ground, my lord, on last occasion, we took time. My lord, I prefer, it is at the final stage, my lord, records are all with us. 1 week, last time.
What do you say, madam?
Lordship.
Weeks time, Mr. Nath is asking for.
Mm.
Mr. Nath prays for and is granted a week's further opportunity of 1 week to file affidavit on behalf of the respondents.
My lord, they have sought more than 6 occasions.
My lord,
As sufficient opportunities have been given previously, in the interest of justice, one last opportunity is being granted to Mr. Nath
Lordship.
for the
My lord,
purpose.
My intent may be considered on the next occasion.
Will consider.
Lordship.
Will re-notify on 27th November. 10 days time. 27th November.
Okay. November.
What happened? September. Sorry.
That's it.
September.
My-
Supplementary list, item 67 to 69.
Well, I was required to go through and bring on record the pay slips. Now, when I called for all the pay slips, we have found discrepancies happening. The department has now put up a committee, my lord, which will now look into as to why some people are getting it and why some are not getting it. My lord, I had to talk with the senior counsel also. Time of 2 weeks, my lord, we'll have the committee look into every aspect and then come back, my lord. So there are discrepancies. Otherwise, at the district level, there are discrepancies.
I have received, my lord, that 8,700
Yes.
seems.
There are some who are getting it.
You file, whatever information you have received, you
Yes,
place
sir.
it on record
Yes, sir.
with affidavit. Then counsel for the appellants, petitioners as well as Mr. Mazumdar, standing counsel education department, pray for and are granted 2 weeks time to bring the facts pertaining to the discrepancy in the pay slips on record.
My lord.
Re-notify on 11th October. 11th October.
Obliged.
My lord, at the last part of the September, my lord.
Last. All right. 28th September.
Yes, my lord, obliged, my lord.
This is item number. Oh. 67.
Top of the list matters, item number 1.
May it please your lordship. My lord, on last occasion, the losses has, my lord, requested my learned friend, learned Advocate General Assam.
Yes.
To talk to the
The
department.
interdepartmental consultation is going on, lordship. It will take some time, lordship.
Let it happen. It's better.
So soon
We are
it's
trying
better
to
for
get
us.
it
My lord,
sorted,
it's
lordship.
pending for 5 years. Usually we want an end.
But
to
we
it.
have at least initiated some process
My
now.
lord, my lord.
Mr. Sinha.
And much obliged that your lordship has taken that initiative.
Mr. Learned Advocate General, Ms. Saikia submits that the matter is under consideration of the concerned departmental officials and
My
a
lord,
decision is expected
my lord, for fixation of the upper limit, that you.
for fixation of the,
No, for revising the whole.
for
act.
revising the,
revising, whether we-
for revision of the ad valorem fees. To enter the entire act,
We are looking into it from that perspective, lordship.
revision of the ad valorem code fee,
Statutory
as
provision.
well as the other provisions of the act. And that a period of at least 4 weeks would be Code Fee Act, Code Fee Act 1870 within bracket Assam. And that at least 4 weeks time would be required to reach to a proper conclusion. For reaching to a proper conclusion, re-notify on 9th November as per it.
My lord, at top
Highly
of the list as to.
The same category. it will come.
My lord, may I file the written notes on argument?
Do it
Because
once we start the hearing, then only do it. It's better.
Deeply obliged.
Item number 2.
Future Lordship. Lordship, may kindly pass over the matter for time being, Lordship.
What is the appeal against?
My lord,
What is the order under challenge?
Lordship,
It is that
APSC may,
the district may.
APSC matters.
Lordship.
All right, pass over.
My lord, can I make one submission in this matter? On the last occasion, Lordship noticed that there were 3 members. The contemporaneous sheet of the, my lord, one of the member was available, and in respect of the other 2, it was not available.
Let Mr. Das comes.
Okay.
She would
All
not
that
be
I
able
was
to.
trying to say is, my lord, according to our information, my lord, these documents have been seized by the police.
Oh, there are 2 documents is not available. Different icon. Different file. That was informed of furnished to I.
I think, my lord, our information is those 2 documents.
I have the instruction. I have got this.
We will just let us take it up in the second round. Then we'll require the Home Department Council to file certain information
Yes,
through the IO.
yes. Whether it has been seized or not.
Yes, we'll check.
Item number 3.
What is the, acha, it is that matter office, no. They did not list it. Oh, these are those Russian card, fair price shop dealers matters. You think we have already reserved judgment?
Relating to.
Let the council come. Let the council come, then we'll reserve the judgment like this one also. Pass away. Call Mr. Saha and Mr. Buragoin. Mr. Buragoin argued, no? Yeah. Call the council concerned.
Supplementary list, item 19 to 65.
I don't know.
उसी से connected है ना? नहीं उससे नहीं. Yes.
My lord, may I kindly have item number 22, my lord.
22.
I'll, in fact, in respect of different service, Assam Civil Service is there, Assam Police Service, then Assam Excise Service.
These are selections of the year 2012,
13, my lord.
13. But recently in the newspaper, there was a report that committee is about to table the conclusions.
That is in respect of, I think, subsequent bets. But regarding the 2013, our information is subject to what my learned friend may say, my lord. Government, I don't think has accepted the
Report.
Yes.
Ms. Nath,
Subject to
do you have
correction.
any information? Any inquiry was made? Inquiry was made regarding this recruitment also.
No.
You're not appearing. Then
BK Sharma.
I'll just apply.
Just one information. 2014 inquiry is going on. 2013, my lord, that inquiry report is before the court.
before
Before them.
government.
Yes, and we brought it by an additional affidavit about the commission of inquiry. Lordship will be shocked. I will argue at this point, at that point, how it was dealt. And the learned senior, with great respect, has come to a finding on the basis of police report. And kindly see the report of the summer commission, my lord. Totally it's contrary.
But what has the government done on that report? What is this?
No, that till today, 2013, that report was furnished to the government. They formed a committee. They formed a committee.
To consider the report.
They, yes, again, the report, they formed a committee. Now, committee, there are 5 grounds which is given. They will now look into whether a private principle of natural justice should be followed. Somewhat which is more tainted, less tainted, the government will look into it. But government doesn't look into our candidate, which was of 2013. They doesn't look into it. They said, no, principle of natural justice is not to be followed. So this is what apparently on the face of record, my lord.
So,
My lord,
Your-
our basic case is to invoke that particular rule, my lord, to discharge the provisioner. There must be some materials based on which, my lord, that satisfaction can be arrived at. Now, my lord, there are 2 things in case of a provisioner. My lord, one exercise could be whether, my lord, a person is fit to be confirmed or not. For that, an exercise is undertaken. In that exercise, if a particular satisfaction is reached by the authority that he is not fit, we cannot because of this and that, then, my lord, one may discharge. Then it will be a termination simpliciter. But when you conduct an inquiry only for the purpose of finding out whether the person concerned is guilty of something, then, my lord, 311 is attracted. Now, in this case, my lord, other than the police report, which was at that stage not even, my lord, charge sheeted, they have acted, and their affidavit clearly says so. They proclaim that we have taken this action based on the affidavit, police report. A police report, my lord, how can that form information within the meaning of Rule 20C? That is the case, my lord. The learned single judge has, my lord, travel to so many aspects, my lord, which I don't think was necessary for the purpose.
okay.
For example, if your lordship would kindly.
Will you please give us a brief outline
Yes.
basically of the entire concourse? Yes.
My lord, this, as far as these present batch of petitioners are concerned, they were appointed by notification dated 12/8/2015, my lord.
Okay. Pursuant to a selection process held
Conducted by the Assam Public Service Commission.
APSC on
Yes.
in the year.
In the year, effectively, my lord, the results were published in 2015. My lord, if your lordship would kindly have the paper book of item 22, my lord.
22.
Yeah. Roomy side, yeah. My lord, may kindly come to page 35.
क्या इतना बंद है ना उन्होंने कहीं घुमा लिया
Page 35, my lord. As per recommendation of the Assam Public Service Commission, wide letter details so and so.
You're reading page 35.
Page 35 of item number 22, my lord.
Just a moment. Yes.
As per recommendation of the Assam Public Service Commission, wide letter dated 12th of May 2015, the following candidates are appointed on probation to Assam Civil Service Junior Grade with effect from the date of joining at the Assam Administrative Staff College, Guwahati. All the candidates are directed to report without fail to the Director of Training, Assam Administrative Staff College, Khanapara, on so and so, for a period of 2 weeks induction training program, and immediately thereafter for a period of 3 weeks of foundation course at the Assam Administrative Staff College.
Yes.
Well, at serial number 59 at page 36 is the appellant before your lordship.
Okay.
Then, my lord, they were supposed to undergo various courses, my lord. Induction training, then, my lord, then revenue training, so many other trainings are there.
Okay.
Now, if your lordship will kindly come to page number 45. Following completion of their training, my lord. In the interest of public service, the following SAS officers are placed at the disposal of the Revenue and Disaster Management Department for posting there as Circle Officer, Assistant Settlement Officer. So they were appointed, my lord.
But they were continuing in probation.
Yes, they were
Okay.
continuing in probation.
Then what happens?
Then, my lord, what had happened? This Dibrugarh police station case, my lord, cropped up. Now,
936/16.
yes, yes. Based on that, my lord, now we.
What is the basic allegation in this?
Yes, now
Yes.
if your lordship would kindly come to page 95, that
Hmm.
is the discharge order, my lord.
Okay.
28th of June 2018. The governor of Assam, in exercise of the power conferred by Rule 20C of the Assam Civil Service Rule 98, is pleased to discharge Srimati Rumi Saikia, Provisional Assistant Commissioner Golaghat, from service with immediate effect. Now, my lord, when we challenge this,
But the earlier two orders refer to the statement recorded in the investigation
yes. My lord, in fact, in their pleaded case in the affidavit is very clear.
on the basis of the police report.
Yes. My lord, I'll just place that.
And why was the appellant placed under suspension?
My lord,
Why was the appellant?
because of the pendency of the criminal case, my lord.
Has she been charge sheeted?
Yes, subsequently they have been charged with it.
Hmm.
Subsequently. It was-
So your case is-
32 to the actual.
Your case is that it is a stigmatic action.
Stigmatic, my lord, you can't, there is no information based on which you could have taken this decision. Because police info report by itself is nothing. It has got no value.
And they have not taken any decision to cost the entire selection process?
No,
No such
some
decision.
of them. Not, a whole selection process was not interfered with. Pick and choose, my lord.
Hmm.
My lord, lordship would recollect, there are cases of the Punjab and Haryana High Court,
Hmm.
where, my lord, three honorable judges of the Punjab and Haryana High Court was constituted, where they found the irregularities. Based on that, my lord, action was taken.
Hmm.
Now here, only action taken is a police report. Well, I'm relying on that affidavit of the government.
It's not there in every
No,
file?
my lord, they file in a particular case. That is
This
in,
lordship, just to assist lordship,
Hmm.
we had filed one and there we had treated one
Adopted
particular
every,
case
in
as a
all
lead.
cases. Okay.
Could
You
I-
represent the state or the APSC?
I'm for the state lordship.
State, okay.
my lord will kindly have para 7 of the affidavit. This is the affidavit which they filed. Affidavit filed by one Ikramul Hussain, Joint
It's
Secretary.
a page number?
My lord, page number 3.
No, the affidavit starts at page number.
My lord, whether it
Yes,
was
page
page.
123,
Yes,
annexure 12.
please come to para 7, my lord. This is the stand. When information was received by the department in respect of the concerned ACS officers,
Hmm.
and the same was verified from the report submitted by the Dibrugarh Police in
Hmm.
June 2018, a conscious decision was taken to invoke provisions of Rule 20C of the Assam Civil Service Rule, 1998 in short, to discharge the concerned officers from the service. It is stated that foundation of the said decision was based on information received and which constituted just and sufficient reason to believe that the concerned officers were ineligible or unfit to be a member of the service.
Hmm.
It is further clarified that while taking such a decision, state respondents were not interested in ascertaining the truth or otherwise pertaining to the culpability of the officers concerned in the matter of their selection. The decision to discharge them from service was taken in public interest for maintaining probity in matters of public inquiry.
Assam Civil Service Rules.
Yes. Yes, well, I've got a copy. Take on this.
And what is the status of these appellants now? They are
Well,
continuing.
No, no, no.
Okay, after the discharge, there was no stay.
No.
No stay in
my
the
lord,
SB also?
No, there was a stay to the extent that those posts will be not be advertised. Subsequently, that was also, my lord, modified.
Okay.
Yes. My lord will kindly have Rule 20, my lord.
No stay lordship by the day.
That he has already stated.
At
Hmm.
page 45, my lord.
Hmm.
A member shall be liable to be discharged from service. C.
Hmm.
If any information received relating to integrity, age, health, character, and antecedent of the governor is satisfied that provisionary is ineligible or otherwise unfit for being a member of the service. Now, my lord, we'll come to the satisfaction of the governor at a later stage.
Hmm.
Now, first of all, there must be some information.
Hmm.
It could not be an ipsi dixit or pretense. It has to be some information.
Hmm.
Issue is, my lord, whether the Dibrugarh police report could have been formed the basis for taking the action. In my humble submission, my lord, it cannot. There are so many judgments of this.
Let's see how this argument has been dealt with by
Yes,
the
yes.
single judge. Let's see.
My lord, we kindly come to the judgment.
Para.
Yes, 1 second, my lord. My lord, we will have item 22, my lord, the other one.
Whichever judgment they take.
Yes, yes,
The
yes, yes.
paragraph you may refer, whichever file it is. The judgment is common in all the cases.
Yes, yes.
You represent all the
Para
appellants.
46.
You represent all the appellants.
My lord, my friend, Mr. D.K. Mishra is also there. Mr. Das is also there.
Okay, okay, very well.
My lord will kindly come to para 46 at page 280.
46.
Clearly, page 40, para 46, page 280. Or para 45, sorry, my lord. The office files as indicated above chronologically records the events taking place following information received from the Dibrugarh police as regards arrest of the petitioner in connection with Dibrugarh PS case. From the decision calling for a detailed report from the Dibrugarh police for taking further action to receiving such report in connection with the arrest of the petitioner, to the decisions to withdraw the services of the petitioner pending action taken by Personnel Department, Government of Assam, to obtaining views of the Judicial Department before taking the final decision, and to obtaining the approval accorded by the Chief Minister, together with the views of the Advocate General Assam before the petitioners were discharged from service by orders of the Governor, the same fines recorded in the respective office file. Clearly, the allegation of irregularities on the part of the petitioners are not allegations of any irregularities, negligence, inefficiency, and misconduct taking place during the discharge of their duties post-recruitment or after having been appointed to public office. The allegation against the petitioner in indulging in gross irregularities and fraud involving payment of illegal gratification for securing appointment to the public office are apparently of a pre-recruitment period, and that is before they are appointed to the public office. In the understanding of this court, the element of misconduct which reverberates in the submission made on behalf of the petitioner is attributable only in respect of a period subsequent to a valid initial appointment. Not a single citation could be placed on behalf of the petitioners for the proposition that irregularities committed during a recruitment process or before appointment had been made or before a person is born into gather service would constitute misconduct. A vain attempt was made when reliance was placed on para 37 of the Palak Modi to say that the use of the unfair means in the evaluation confirmation test would certainly constitute misconduct. Reliance was placed vis-a-vis the facts and circumstances in the present case, it is altogether out of context. In Palak Modi, the private respondents there were already appointed as provisionary officer way back in 2006. In due course, State Bank informed that they were due for confirmation in service and therefore they were to appear in the test proposed to be conducted on 27/11. The private respondents appeared in the test held on 27/11, but their names did not figure in the result declared on 10/5/11. Primarily on the ground that the Institute of Banking Personnel Selection, which body was entrusted with the task of preparing the examination papers and evaluating the answers, it submitted a report to the bank that some of the candidates, including the private respondents, were suspected to have used unfair means. Thus, paragraph 37 of the Palak Modi, which makes mention of use of unfair means during evaluation test, confirmation test, would constitute misconduct only in respect of test conducting for the purpose of confirmation in service. No law was laid down in Palak Modi that misconduct can be stretched back to the period prior to entering into service and for illegalities and irregularities committed during the selection process. As misconduct cannot be a pre-recruitment phenomena, the very bedrock of the submission made on behalf of the petitioners, that impugn action being founded on misconduct, therefore the principle of natural justice or provisions of Articles 11 could not have been dispensed with in the considered opinion of the court does not hold any water. Indeed, there can be no hiding from the fact that arrest and materials corrected against the petitioner following the FIR dated so-and-so, registered as Dibrugarh PS case number 936 of 16, had set the ball rolling. Investigation report of the Dibrugarh police were foundational facts, the gravity of which was considered by the government of Assam in the Personnel Department, which eventually resulted in the orders being passed, preceded by consultation with concerned departments obtaining the views of the judicial department and with the approval of the highest government authority. Impugn actions are only in respect of an identifiable group section of the candidates who had appeared in the mains examination. The identifiable group are only those candidates where their duplicate answer sheets after submitting their original sheets were recovered from the confidential examination branch of APSC as well as from the house of the chairman, Sri Rakesh Paul. This identifiable group alone were discharged from service against whom charge sheet has been filed. There are 52 writ petitioners herein and another 8 candidates who are not before this court. Allegations are with regard to criminal conspiracies resulting in tampering with the examination process for benefit of the petitioners herein. Investigations have revealed that petitioner had indulged in unfair means of for getting selected by paying bribe or on extraneous consideration, but certainly not on account of merit. There are cogent materials on which the respondent authority derives satisfaction that selection process to which the petitioners came to be selected and eventually appointed was tainted by fraud. The irregularities in the selection and appointment of the petitioners being founded at the threshold itself, can it be said that the state action was not bona fide in discharging the petitioners from service? And was it not the solemn duty of the state to take the impugn action for maintaining sanctity and in reposing faith in the system and public office in relation to affairs of the state government? Can it be said that it was not open to the state government to act on the disturbing revelations emanating from the police investigation with regard to grave illegalities being discovered from the petitioners during the selection process, which illegalities occurred well before they had entered into service? To reiterate, the discharge of petitioners from service was not on account of any alleged misconduct after appointment, but discovery of fraud at the point of their very entry into service. There is a clear dividing line between challenge made to an order of discharge on the ground of misconduct during post-recruitment period and a challenge made to an order of discharge on the ground of irregularities and illegalities finding place to a pre-recruitment period. Whereas the former would invariably invite compliance of the alteram partem rule of natural justice and or compliance of the protection guaranteed under Article 311 of the Constitution. The latter can fall within the category of exceptions to the rule of audio alteram partem, particularly if there are reliable materials to reach a satisfaction that it is, so far as petitioners are concerned, the examination process and the selection was vitiated. Going back to Purushottam Lal Dhingra and Shamsher Singh, it is only when termination is seen to be founded on manifest misconduct, it will be a punishment and will go to violate Article 11 of the Constitution in absence of an inquiry. However, as observed above, the argument on misconduct being founded are wholly misplaced and misconceived inasmuch as discharge of the petitioners from service was not founded on the phenomenon of misconduct as is understood in service jurisprudence. The Dibrugarh police report following investigation are part of the records, and a compilation of the same has also been furnished before this court by Mr. D.K. Mishra, Lanet Senior Counsel, during the course of the hearing. It is seen that illegalities and irregularities discovered in the selection had been scrutinized and investigated upon in respect of each of the petitioner. Detailed police investigation enabled to pick up the candidates who had unlawfully benefited. A mere perusal of police report leaves no room for doubt as to the thoroughness with which the investigation was carried out. Irregularities attributed against each of the petitioners are minuted, reinforced by statement made before investigating officer by such petitioners as available in record, admitting to their complicity. Having gone through the police report, privacy view of the court is that same comment itself to acceptance. The question is, could such selection in respect of petitioner be acted upon in matters of public import? And also whether state respondent could have acted on police report to eventually discharge the petitioners from service. No law is cited on behalf of the petitioners to support the view that there is a legal embargo in acting upon a police report, as is seen to be done in the present case. On the contrary, decision in Krishna Yadav and O. Chakradhar goes to support a contention that police report can be acted upon. This court therefore would hold that the orders of the discharge, which are subject matter of challenge in the present case, do not suffer from any legal infirmity, only on the contention that impugn orders are based on foundational fact emanating from the reports of the Dibrugarh police. Orders of discharge from service founded on police report are one thing, and orders founded on misconduct are altogether different aspect or proposition. What is relevant in the present case is to ascertain whether orders of discharge were founded on misconduct as understood in service jurisprudence. That has already been answered in negative in the preceding paragraphs of the judgment. My lord, in my humble humble comprehension, my lord, the learned single judge made distinction between
Post-selection misconduct and pre-selection misconduct.
In fact, my lord, Supreme Court never recognized this distinction. Palak Modi is an authority for the proposition. If somebody resorts to any wrongdoing, even at
That
the
was during the confirmation test.
yes,
Palak Modi, from what we could get
yes,
from the judgment,
yes.
it deals with a situation
Huh.
when there was a test for confirmation in service,
Hmm.
which would be, say, 20B,
Huh.
departmental examination. And during that course,
They were
they were found.
but that was again a test for confirmation.
Yes.
Here it was a test for selection. No, my lord,
So
end of the
that's a
day.
fundamentally different
No,
situation.
no, that's all right, my lord. My lord, if we have to accept the views of the learned single judge, then trial is not required, my lord.
No,
No trial is required.
nobody is convicting them.
No, my lord.
This is see, there is a manifest difference
No, my
between confirmation of a probationer and termination of service of a confirmed employee.
My lord, the learned single judge has taken note of these two judgments, Krishna Yadav and O Chakradhar. My lord, these were judgments where there was a preliminary inquiry conducted by CBI. And preliminary inquiry is nothing but is an administrative report.
Okay.
Both the cases, my lord.
Yes.
Now, how can police report, my lord, police report, Honorable Supreme Court in Khatri's case.
Please come to
Huh.
para 47 once again.
Yes,
What is the material which had been collected?
my lord, we are not disputing the materials. Question is whether
What
these
is the
materials.
material collected, sir? What is the material? What is the nature of the material collected?
No, my lord, whatever is the material, it is a part of the case diary.
Maybe,
It is a police
maybe,
report.
maybe.
It is
It is considered by the state, none else. It is not made a public
No,
document.
my lord, question
Before
is
filing of
whether these materials which are enlisted in para 47, if these are the materials which are enough to invoke Rule 20C.
Arrest. The recovery of
Very well.
the replaced
Yes.
copies.
Yes.
What more
No,
is
no, my
required?
lord, therefore, in my humble submission, my lord, these are no materials in terms of 20C.
Okay, very well.
It must have some legal sanctity, my lord. Otherwise, my lord, what meaning we give to section 25 and 26 of the Evidence Act? What meaning we give to section 33 of the Evidence Act? My lord, in fact, I'll just place one judgment, my lord, since I think it's very relevant, that Bhagalpur blinding case, Khatri. Please have that, my lord. When in a 226 proceeding, police report would be relevant. Nineteen 81. Listen, this
Referred to in a 226 proceeding.
my lord.
These police reports were part of the state action
Hmm.
in deciding not to confirm the services.
Had these findings been recorded following an administrative inquiry, things would have been totally different.
Okay, very well.
That, my lord, if your lordship will kindly see that Punjab case that Joginder Pal and Indrajit Singh Khailon, where, my lord, the committee of the three honorable judges of the Punjab and Haryana High Court gone into the aspect, they recorded the finding.
What is the status of that inquiry committee in law? Tell us.
It's an administrative inquiry, my lord, because they are directed by the Supreme Court.
Administrative inquiry, was it a bipartite inquiry or in-house inquiry?
In-house.
So in-house inquiry, they have got conducted. They have taken the report of the Advocate General. That is what the judgment reads.
Advocate General's opinion is another thing. My lord,
Yes.
routing through the Department of Personnel, but that's a different aspect.
So
And
all that action is an in-house inquiry,
my lord,
which was conducted on the direction of the Honorable Governor.
only thing is, number one,
Hmm.
whether this police report could form
Not
the
only the police
information.
report. Chaudhary, not only the police report. What
materials
material was collected?
materials
That is
collected.
substantive material
No,
as per the
materials-
learned single judge.
No, my lord, materials collected and which form part of the police record. Case
Yes.
that. Whether that could have formed the basis for
All right.
invoking.
Let us see any law to the
Yes,
contrary.
yes.
Yes.
My lord, let me then, since the learned single judge relied upon the two judgment of
Whichever.
Krishna Yadav, let me
You
place those.
proceed as per your convenience.
My lord will have 1994, 6 SCC, list on this. 1994, 4 SCC. No, very good.
Just to assist lordship, we had given a compilation of judgments. They would be part of the Kunal Das matter. There are 4 volumes. With these-
Judgments which are being cited by
Yes,
Mr.
Lord.
Chaudhary.
So the state had given 4 compilations in the Kunal Das matter.
For now, you know,
So in that, the 4 compilations should be there.
31.
Before the single judge, we had given it.
Hmm.
Item 31 today.
No, it was silent. 1994, 4 SCC 165.
Yes.
My lord will kindly come to paragraph 4 for the facts. Four, 5, and 8 for the facts. The board conducted the written examination at various centers in the state of Haryana on 17/12/88 and 18/12/88. On receipt of the answer book from different centers, a key book was now got prepared by the secretary of the board with the help of the confidential branch. This key book contained the following particulars: the name of the candidates with the parent's name, roll number, details of the subject of written test. Fictitious roll numbers were allotted to each candidate in the key book by removing the original roll number slips. Thereafter, the answer books were sent to different examiners for evaluation. After examining the answer books, the examiners were required to prepare an award list, which is the summary indicating the fictitious roll number of the candidates and the marks obtained by them in each subject. On receipt of the answer book, the marks obtained by the candidates in each subject were entered in the key book. On the basis of the key book, award list, and the answer book, the result of the written test was prepared by the board. Therefore, the same was published by displaying it in the notice board. Para 8, my lord. Originally, respondent number 4, Anand Singh Dangi, was the chairman of the board. He resigned. After his resignation, a new chairman in his place was appointed by the state government. After appointment of the new chairman on the next day, the select list for the post in question was finalized. The list was sent to the department secretly. This was in clear violation of the norms which requires publication on the notice board so that it could be made known to the public. The selection list was kept in a highly secret document. The same was sent to the second respondent by hand. Appointment letters were issued after calling these selected candidates. Joining report from all selected candidates are obtained in Chandigarh on the spot. Some of them were shown to have joined the respective place of posting. No medical examination for the selected candidate was conducted, nor there were antecedents got verified before the actual appointment. This will clearly establish that favoritism, nepotism, unfairness, and good deal of political influence played a vital role in the selection, disregarding the merit altogether. For the reasons based on the original records, including the answer books, are destroyed, this is attacked by the appellant as an attempt to cover the illegalities committed by the board. Primary on this allegation, several writ petitions were filed before the High Court of Punjab and Haryana. The facts as attributable to so-and-so were taken into consideration. The High Court was of the opinion that in view of the fact that all answer seats and tabulation seats having been destroyed, the allegation of petitioner therein could not be ascertained. The award of 100 marks for Vayavuse would work out to 28.5% of 250 marks. This was not excessive. Ultimately, a direction was given not to fill it beyond the advertised number of posts of 76. The other writ petitions came to be dismissed by applying this ratio. Then my lord will kindly come to paragraph 13, my lord. I'm sorry, my lord, para 12 at page 169. In view of the serious allegation made, particularly the destruction of the records alleged to be for want of space, this court passed an order on 9/10/91 directing government of Haryana to refer the matter to the CBI for investigation and to complete the investigation within 3 months. The time for completing the investigation was extended. The Supreme Court Superintendent of Police SP CBI Chandigarh has filed a detailed report. We record the same. The argument on behalf of the appellant addressed by the learned counsel Govinda Muktogi and A.K. Ganguly may be summarized thus. This is a clear case in which various acts of nepotism and favoritism has been committed. The whole selection is arbitrary. Very conveniently, destruction of records is pleaded. Unfortunately, the High Court has not given much attention to the allegation and examine the veracity of this allegation. When the respondent sought cover under the destruction of record, that plea had come to be accepted. As a result, the appellant's allegations could not be verified. This is hardly the way to render justice. Fortunately, before this court, there is a report of CBI.
This was a report subsequent to the action having been taken.
Yes. No, my lord, here in this case, lordship knows, CBI conducts first a preliminary inquiry.
Right.
On, gathering the facts, they submit a regular inquiry. The regular inquiry is something like, my lord, the case has been registered. But until the stage of preliminary inquiry, it is an administrative exercise. So what, in my humble submission, my lord, subject to what your lordship may say, now please come to para 15.
Yes.
It is not possible for this court to enter into factual domain and decide the case one way or other. We have already mentioned about recording the report of CBI. We will go only by that, as the report comments itself to acceptance. In our considered opinion, CBI has done a commendable job and has not failed to call a spade without shielding anyone concerned, including the minister. We'll extract this one, sir. So in my humble submission, my lord, the preliminary report of the CBI, it took firm basis for the purpose of invoking similar provision. Certainly not a materials following investigation of a case, my lord, which is a part of the case diary. Otherwise, my lord,
What is a progress report by the police during investigation?
no, those are there, my lord. Those even now.
What else it is? What is the character of that report, sir? What is the character of that report?
Of the
The report which the police files in the court while the investigation is going on. What is the nature of that report?
No, my lord, eventually on completion under 173.
That would be a report under 173. That can be supplemented by additional reports. But in the intervening period, till the report under 173 comes to be filed, there are progress reports which are filed along with the remand applications.
From time to time.
Yes, along with the remand applications.
No, my lord,
What is the nature of that?
no, that
report?
nature, it continues to be a police report, other than the report final.
So why the report of CBI is not a police report?
No, it's a police report, but it is an administrative report, my lord. Now, following this, when a regular case is to be registered, then only it will take the color of a criminal investigation.
Okay.
Until then, it was not a.
So your argument is
yes,
that there is a distinction between
yes,
a preliminary inquiry conducted by the CBI and a police report after registering a case.
Yes.
All right.
That was not done in this case.
Okay.
And my lord, the learned single judge very candidly said everything is based on the Dibrugarh police report case.
Okay.
Now please come to the other case, my lord. The other one is 2002 3 SCC 146.
Yes. 146. Chakradhar.
Yes. O Chakradhar, my lord. My lord will kindly come to para 4 for the facts. The Central Administrative Tribunal, while deciding the case, held that merely saying that serious irregularities were committed in conducting the selection or that typing test was not held, such general allegation could not be enough to take a decision to cancel the whole selection. It is also observed that the show cause notice which was issued is silent about any irregularity in the selection which could be attributable to the applicant. Therefore, the show cause notice was inadequate and incomplete. It has further been observed that report of CBI cannot be the only refuse for cancellation of a selection, but its contents should have been brought to the knowledge of the applicant in a concise form to enable him to give a proper reply, but it was not done by the administration. Thus, in the absence of proper notice and appointing an opportunity to the candidate, the order of termination of the applicant stands vitiated. The tribunal also observed that CBI report was not placed before it. With the above finding, the termination order was set aside, providing that proceeding could be initiated de novo by issuing fresh show cause notice in the light of the observation made in the judgment. The writ petition preferred by the appellant against the order of Central Tribunal was dismissed as indicated earlier. The judgment of the High Court in the writ petition is also based mainly on the ground of violation of principles of natural justice, and that of notice which was given to the candidates was vague, which amounted to no notice at all. Hence the cause of action, hence no proper cause of action to this court against such a notice. Mr. Mukul Rohtogi learned so appearing for behalf of the appellant has placed reliance on the decision of this court in Krishna Yadav on the basis of the same, it has been vehemently urged that in case where irregularities committed in the process of selection is all pervasive, vitiating the whole selection, in that event, it would not be required that each selective is served with individual show cause notices. In such circumstance, it will be open to cancel the whole selection. Sri so-and-so learned senior counsel appearing for respondent has however urged that it was necessary to make known to the respondent appointee about the exact and precise nature of the irregularity committed, as well as the misconduct, if any, attributable to him, so that it could be possible for him to have explained the position which has otherwise adversely affected the respondent. It is further submitted that the order of the termination is in clear violation of Article 311 of the Constitution, as on the basis of the so-called notice as issued, it was incumbent upon the appellant to hold an inquiry and then alone pass an order of punishment, not otherwise. It is also submitted that according to report of the CBI, the beneficiaries of the irregularities could be identified and person against whom action has been recommended were named therein. Name of the respondent appointee is not amongst those against whom the actions has been recommended. The submission is that only those who got benefit of irregularities, if any, committed by the Railway Recruitment Board should have been issued notices and actions could have been taken again. All others, including the respondent, had nothing to do with any kind of irregularity and who have been selected on their own merit. Their services are not liable to be terminated. Then my lord will kindly come to para 8. In our opinion view, the nature and extent of the illegalities and irregularities committed in conducting selection will have to be scrutinized in each case so as to come to the conclusion about future course of action to be adopted in the matter. If the mischief played is so widespread and all pervasive, affecting the rights result so as to make it difficult to pick out the person who have been unlawfully benefited or wrongfully deprived of the selection, in such a case, it will neither be possible nor necessary to issue individual show cause notices to each selectee. The only way would be to cancel the whole selection. Motive behind the irregularities also has its relevance. The copy of the report of the CBI has been made available to the court by the learned Additional Solicitor General, and the same was served upon the learned counsel for the respondents earlier. To find out the position in the present case, we may have to scrutinize the report. Therefore, my lord, now if your lordship will kindly come to para 12.
Yes.
As per the report of the CBI, the whole selection smacks of malafide and arbitrariness. All norms are said to have been violated with impunity at each stage, right from the stage of entertaining the application, with answer sheets while in custody of the chairman, in holding typing test, in interview, and in the end, preparing the final list. In such circumstances, it may not be possible to pick out or choose a few persons. Anyway, my lord, whether whole thing should have been cancelled or my lord,
Selective decision should have been.
But end of the matter, my lord, this is also a case based on preliminary report of the CBI, which was pursuant to which no regular case was, my lord, registered.
This judgment does not reflect so. It talks of a report, but what was the nature of the report is not very clear.
Not very clear.
Yes.
But at least, my lord,
This doesn't even say that it is a preliminary report.
But the other case is clearly.
Right.
No, this was relied upon by them. The learned single judge relied upon. Now, my lord, let us come.
You try to draw in distinction, preliminary report, but the second judgment which was cited, it doesn't give a reference to any preliminary report or a final report.
Now, my lord will kindly come to this two judgment is a very important in my humble submission. My lord, Jogendra Singh Tagore is na? Indraprit Singh Kahlon, my lord, 2006 11 SCC 356.
Yes.
My lord will kindly come to para 40. At page 383. We may at the outset would furthermore notice that having regard to the submission made before us by Mr. Dwivedi and Mr. Rao, that services of the appellants before us were terminated not in terms of the rule, but in view of commission of illegality in the selection process involved, we need not consider the applicability of the relevant provisions of statutes, as also the effect of the provisions of Articles 10 and 11 of the Constitution of India. An appointment made in violation of Article 14 and 16 would be void. It would be a nullity, but before such a finding is arrived at, the appointing authority must take into consideration foundational facts. Only when such foundational facts are established, the legal principles can be applied. If service of the appointee who have put in few years of service are terminated, compliance with three principles at the hands of the state was imperative. To establish satisfaction in regard to sufficiency of the material collected so as to enable the state.
Mr. Chaudhary, you have to keep in mind that there is a distinction in termination of confirmed services and non-confirmation of a probationary.
Yes.
Is it a case
Yes.
of non-confirmation of a
Yes,
probationary?
my lord. It was also a case of my lord selection by the Public Service Commission.
No, non-confirmation.
Yes, non-confirmation.
That there will be a huge difference
Yes.
in consideration.
Yes, yes. No, my lord, but in my humble submission, subject to what your lordship may say, whether it is in case of a confirmation of a provisioner or my lord, in case of a provision, confirmed employee, there is no question of discharge. He has to be dismissed. Or my lord, removal of service or compulsory retirement, whatever. To establish satisfaction in regard to sufficiency of the materials corrected so as to enable the state to arrive at a satisfaction that the selection process was tainted, to determine the question that the illegalities committed would go to the root of the matter, which vitiate the entire selection process. Such satisfaction as also sufficiency of material were required to be gathered by reason of thorough investigation in a fair and transparent manner. Whether sufficient materials present enable the state to arrive at a satisfaction that the officer in majority have been found to be a part of the fraudulent purpose or the system itself was corrupt. Lord, I'm just posing a question, my lord. Whether, my lord, the police report or the materials which comprised in that police report would come within this ABC, my lord, 1, 2, and 3. Certainly it will not come, my lord. Once such findings were arrived at, all important appointments traceable to officers concerned could be cancelled. But admittedly, although there had been serious imputation against Sidhu, being the helm of the affairs of the commission.
Mr. Chaudhary, clause 1,
yes,
which you are referring to,
yes,
it talks of satisfaction of the state. Would it not be subjective satisfaction? Has to be. You can't consider it to be
the satisfaction could be subjective, but the materials must be objective.
Yes. So the satisfaction is there. It refers to the material, existing material. That would be an objective material. It's not in thin air that they have taken note of a newspaper report.
No, whether an information contained in a case
not only the information
can be basis for taking an administrative action.
Not that information contained in case diary, had it been the exit of the IO, the opinion of the IO, different matter. But substantive material, seizures made, searches made, arrest made.
No, my lord.
These are substantive documents.
My lord, the persons are presumed to be innocent, my lord, until they are proved
We are not convicting them.
No,
in service law,
no,
that is not the principle.
No, my lord, even for taking an administrative action, whether, my lord, in my humble service, these are all ipsit.
All right.
Can't even constitute to material. Otherwise, my lord, what meaning we give to section 25 and 26 of the Evidence Act? One such finding were arrived at all appointments traceable to the officers concerned would be cancelled. But admittedly, although there had been serious imputation against Sri Sidhu, being at the helm of the affairs of the commission, all decisions made by the commission during its tenure are yet to be set aside. We do not intend to enter into the said controversy, as we are informed at the bar. The High Court itself is in session of the matter. Kindly see, my lord. We may, however, note that the debate
session of the matter regarding taking action to quash all actions taken under the regime of Mr. Sidhu.
Sidhu.
So now
No,
next
but High Court was in session of the matter regarding judicial appointments. High Court conducted an inquiry. I'm coming to that, my lord. Apart from the inferences drawn on certain facts and in particular the circumstances enumerated by the High Court, which have been repeated by the learned counsel for the state before us, it is difficult to accept that it was demonstrated by the state that it was absolutely impossible for it to separate the innocent people from the tainted ones. 44. It is also a case where all the relevant records have been destroyed. The Vigilance
Not a
Bureau does
case.
not say so. Question
Not a
paper-
case.
It is not a case. I'm sorry. Yeah. Not a case and so. The Vigilance Bureau does not say so. The question paper, answer sheets and other documents are available. The report made by the Bureau were prepared upon examination of material collected by it. The High Court itself has noticed that it is what is not available in records relating to procedure adopted in regard to the appointment of the paper setters. It may be true that such records could be destroyed only after a period of 5 years, but it has not been pointed out by the state as to how. By reason of the non-availability thereof, it became difficult for the authorities to arrive at the correct facts. We have not been informed that connecting materials were also destroyed. It has been noticed by the High Court that all relevant information was available and submitted to the court. It cannot therefore be said that a fair investigation into the whole affair was an impossible task, or despite availability of such record, a thorough investigation had been made so as to arrive at a satisfaction that the entire selection process suffered from a large-scale fraud. It has also not been found that all appointments were made on extraneous consideration, including monetary consideration. If fraud in the selection process was established, the state should not have offered to hold a reselection. Seniority of those who were reselected ordinarily could not have been restored in their favor. Such an offer was evidently made as the state was not sure about the involvement of large number of employees. A distinction, moreover, exists between a proven case of mass cheating for a board examiner and unproven imputed charge of corruption, where appointment of a civil servant is involved. Then, my lord, will kindly come to paragraph 90 to 95. Para 90 at page 399. The High Court was probably enthralled by the media reports that two of the wards of its sitting judges obtained appointment wrongly. It is, however, stated at the bar that they were toppers of the bets, and in his information report, their names had not been mentioned. Only because wards of his sitting judges obtained employment, the same by itself would not give rise to the presumption that everything was not well in the selection-making process. We, having regard to the peculiar facts and circumstances of the case, are of the opinion that it is necessary to direct consideration of the matter afresh. We have not been apprised whether criminal case any further in the criminal case any further materials have been gathered so as to implicate the appellants before us. We are, however, told some of the new appointees appointments have been made, and the effect whereof would certainly be subject to the decision of this case. We, however, do not intend to set aside said appointments at this stage. We also do not intend to disturb the status quo. That 94. The impugned judgment is also the order of the state government and the High Court are thus liable to be set aside, and directions are issued, although the impugned judgment cannot be sustained, we are of the opinion that the interest of justice would be subserved if matters are remitted to the High Court for consideration of the matter afresh. However, with a view to segregate the tainted from non-tainted, and that in the interest of justice, the High Court should be requested to constitute two independent scrutiny committee, one relating to executive officers and other relating to the judicial officer. We would further request the High Court to consider desirability of delimiting the area which should fall for consideration by such committee within a time frame. Copies of such reports of the committee shall be supplied to the learned counsel for the petitioner, or at least they should be given inspection thereof. The parties shall be given opportunity to inspect the documents, including the answer sheets. If an application in that behalf is filed, such inspection shall, however, be permitted to be made only in the presence of an officer of the court. The appellant shall be given 2 weeks' time only for submitting their objection to such report and their comments, if any, on any material whereupon High Court's place reliances from date of supply copies of inspection is given. Having regard to the fact that the appellants are out of job for a long, we would request the High Court to consider desirability of disclosing the matter as expeditiously as possible, preferably within a period of 3 months from the date of receipt of this order. So, my lord, Supreme Court did not act on the materials, instead directed an inquiry.
Because that was a decision to cancel the entire
Entire
selection.
selection.
Supreme Court said, separate the chaff from the grain.
Separate
That has already been done here.
Where?
That exercise has already been done in this case.
By
Wherein
whom, my lord?
only those persons who have been found involved, they have not been confirmed.
Well, who has done it? Administrative
that's-
authorities have not done it, my lord.
Okay, okay.
All right, my lord will kindly come to the next judgment following this Joginder Pal. My lord, 2014, 6 SCC 644.
Yes.
My lord will kindly come to paragraph 10, my lord.
Mhm.
10.1. An appointment made in violation of Article 14 and 16 of the Constitution would be void. It would be nullity since the service of the appellant were terminated not in terms of the rule, but in view of the commission of illegality in the selection process involved. The applicability of the relevant provisions of the statute as also effect of provisions of need not be considered. Well, these are the observation of Indrajit Khelon, my lord. So up to, I think, para 10.4, my lord, it was the observation in the earlier case. Now, please come to my lord, para 11. Or para 10.5, sorry, 10.4, my lord. Cases which may arise where selection process is perceived to be tainted may be categorized in the following manner. Cases where where the event has been investigated. Cases where severe inquiry took place and was completed or a preliminary investigation was conducted. Cases where selection was made but appointment was not made. Cases where candidates were also ineligible and the appointments were found to be contrary to the law. Herein 2, my lord, speaks of preliminary inquiry of the CBI. Cases where candidates were also eligible and appointments were found to be contrary. If the services of the appointees as put in fears of service were terminated, compliance with the three principles at the hands of the state was imperative. And that is as to establish satisfaction in regard to sufficiency of the materials collected, so as to enable the state to arrive at the satisfaction that selection process was tainted. To determine the question that the illegalities committed went to the root of the matter which vitiated the entire selection process. Such satisfaction as also sufficiency of materials were required to be gathered by reason of thorough investigation in a fair and transparent manner. Whether sufficient materials present enable the state to arrive at the satisfaction that the officers in majority had been found to be a part of the fraudulent purpose or the system itself was corrupt. Once the necessary factual findings as enumerated above are arrived at, it is found impossible or highly improbable to separate tainted from untainted cases. All appointments traceable to the officer concerned could be cancelled. But admittedly, in the present case, although there had been serious imputation against Ravinder Pal Singh Sidhu, being at the helm of the affairs of the Public Commission, all decisions made by Commission during this tenure are yet to be set aside. Applying this principle to the facts of the case, court in Indrajit Singh Khelon found that no candidate for the year 2021 been appointed, and therefore persons who were selected in that year were on a different footing. As merely a person comes in the select list, he has no right to be appointed on that ground. However, held the court that those who had already been appointed and completed about 3 years of service, some of them have even passed the departmental test, and some were given higher responsibilities, and that even completed the period of provision or nearing completion thereof, or are working in the satisfaction of the authorities concerned, different yardsticks are to be applied while terminating their services. As a matter of fact, the court found that from the inferences drawn on certain facts and in particular the circumstances enumerated by the High Court, it was difficult to accept the contention of the state government that it was absolutely impossible for it to separate the innocent candidate from the tainted. In the opinion of the court, by appointing an independent scrutiny committee, it was still possible to shift the evidence and separate the tainted candidates from the innocent ones. The court also recorded that the relevant records were still available and had not been destroyed, which included question papers, answer sheets, and other documents. Since these records were still available, a fair investigation in the whole affairs was still possible. Such an exercise therefore needed when it had not been founded that the appointment were made on extraneous consideration, including monetary consideration. It was thus held that the High Court was not right in applying the principle of mark setting in the instant case. This court in Indrajit Singh Kahlon concluded that the matter in the following so.
Mr. Chaudhary, your answers lie in paras numbers 18 onwards.
Yes.
Tell us how you get out of these observations.
My lord, para.
Para 18 onwards.
Yes.
Precise answer to your arguments.
The particulars of the candidates who are facing criminal trial are as under. Okay. As far as these cases are concerned, they hardly pose any challenge. It is specifically found that aforesaid persons have indulged in unfair means and have been selected either by paying bribe or because of other. No, my lord. There's a difference.
Please carry on. Come to para 2.
For a moment, I'm not trying to shy away from the facts.
Reach para 22.
Okay. In respect of the appellants, the High Court has found that FIR had been registered against them and they were they definitely carry a trace, stain, or blemish that they were tainted. FIRs are registered when during the investigation, the Vigilance Bureau recorded statement of Mr. So-and-so. The modus operandi of conducting the manipulation written examination were disclosed by them. Question papers were given to Mr. Jagmohan Singh to be shown.
Do these not constitute part of the case diary?
My lord.
What is referred to
No,
in
my
para
lord, they did not only refer to this. There were the committee's report, 3 judges committee. Yes, and those confessions were also there. No, my lord, let me read the whole judgment.
Very well, very well. You carry on at
No,
your
lord,
own pace.
All that I'm trying
You carry
to.
on at your own pace.
No,
All right.
all that I'm trying to satisfy your lordship is whether the materials contained in the case diary
Yes.
would have formed the basis for arriving at the requisite satisfaction.
That is the only foundation of your argument. Okay.
Now, para 23, my lord. In this backdrop, High Court rightly covered these persons as tainted, ascribing the following meaning. Therefore, all the appeals are dismissed except civil appeal number so-and-so, in as much as against him no case is registered and ultimately found innocent. We shall deal with this case a little later. Now, please come to para 40.
The report of committee was referred to in this judgment only to examine the case of the untainted candidates.
Yes.
So far as the tainted candidates is concerned, their fate was decided long back. FIRs registered, material collected, closed their matters. For untainted candidates, because the High Court had quashed the entire selection.
Yes.
So that distinction was sought to be drawn for untainted. That is the exercise which you are reading. This is an exercise to find out those who can be saved on the basis of the inquiry report.
Yes. No, but my lord, what meaning, lordships, we give to para 10.4 of Indrajit Singh Kahlon?
You already read para 40. You will get the answer.
After the judgment of the Indrajit Singh Kahlon's case, a committee of the 3 judges of the High Court was constituted with specified task to separate the tainted candidates from the non-tainted candidates selected to the executive board by the Public Service Commission. The committee undertook the mammoth and painstaking task with deep scrutiny of cases of each and every candidate. This committee submitted its report dated 8/2007. It is pertinent to note that the committee could achieve the task of segregating the tainted candidates from the innocent ones.
This was segregated
Meaning thereby-
only on the basis of material collected by police. This exercise of the committee was only to analyze the police report and find the tainted and the non-tainted candidates.
At least,
Final conclusion was, of course, the entire process should be
my lord,
squashed.
at least, my lord, what was gathered by the, my lord, police, or at least a committee of the three honorable judges of the High Court gave a finality to it, my lord.
That was necessitated
Therefore-
because these were candidates who were confirmed, on whom Article 311 clearly applied.
No, my lord, that will be.
Herein, these are people
No, my lord, that
who
will
are
be a-
yet to be confirmed. in
That will be a
service.
different argument, my lord. When, my lord, a provisional is sought to be, my lord, discharged or removed based on allegation whether 311 will be attracted, that is a different argument.
It's not a removal based on an allegation in service conduct or regarding to in service conduct.
No, my lord.
It's something which happened earlier.
No, even for that, my lord, inquiry is paramount. I'll place those judgments.
We'll
Yes.
read the judgment.
Yes.
Right. Okay.
So, my lord, as far as Indraprit Singh Kahlon and my lord.
They are based on the conclusions of the High Court,
Yeah.
3 judges inquiry.
Yes.
Therefore, they are
Therefore,
distinguishable.
the legitimacy can be attached because, my lord, the objectivity of the materials, my lord, became more pronounced when the committee of the 3 judges gave an approval to it. It was per se, not the police report, my lord, as in the present case.
But the Supreme Court did not even rely upon the 3 judges committee report.
No, for the purpose of, my lord, segregation, Supreme Court did.
Segregation, but not accepting the recommendation for the non-tainted candidates.
No, my lord, even in respect of them also, the committee has gone into each and every case was examined.
Yes, all right.
Now, my lord, please come to the judgment. Facts to lage. Now, my lord, I have dealt with 2 aspects. The first aspect was the learned single judge perhaps wants to draw a distinction between misconduct following appointment and, my lord, a person while entering into service.
Tainted means.
Conduct is, my lord, not above the board. Therefore, according to the learned single judge, the judgments we referred before the learned single judge, none of them pertain to a situation where the selection, at the time of recruitment, any illegal
The misconduct was committed after joining service.
And the second aspect is the learned single judge relied upon, my lord, Tulsa Yadav and O Chakradhar for the proposition that police report can form basis for taking an impugned action.
Okay.
And thirdly, my lord, by referring to Indrajit Kahlon and my lord Joginder Pal, what perhaps, my lord, I would respectfully submit is that satisfaction can be derived only from material which is relevant. A police report per se or the materials contained in the police report cannot form basis because it is not in the nature of an administrative report. Well, nothing prevented the state from conducting an inquiry. Well, we are concerned with the decision-making process. We are not saying the state is not competent to take action against persons who, according to the state, my lord, have entered into service by following dubious means.
Yes.
By all means, you have the power.
The
Question
next
is,
argument, Mr. Chaudhary, would be that mere filing of the police report makes no difference. It is innocent till proved guilty.
yes.
So,
No.
so till the trial goes on, the man remains in service.
No, I won't state that to that extent, my lord. But all that I'll say is, for taking an administrative action, that to do dispensing with the service of a person without notice, whether a police report can form basis.
Very good. Okay.
With that, my lord, it's a very serious matter, my lord.
Yes, yes.
Or else, my lord,
We never
the
said that
executive
you are
will
not.
be clothed with, my lord, such a
Mr.
power.
Chaudhary,
which
we
is
never,
not even
we
comprehend.
never indicated that we are not taking you seriously at any given point of time after 15th February. Yes, carry on, please.
Yes. My lord, I'll refer to this judgment that Palak Modi, my lord, first. Palak Modi, yes. Palak Modi is, my lord, 2013 3 SCC 607.
You not given the list in advance.
I've given, my lord. Wait, wait, wait. The court will explain it also, sir. My lord will kindly come to para 25. The ratio of the above noted judgment is that a probationer has no right to hold the post and his service can be terminated at any time during or at the end of the period of probation on account of general unsuitability or for the post held by him. If the competent authority holds an inquiry for judging the suitability of the probationer or for his further continuance in service, or for confirmation, such inquiry is the basis for taking decision to terminate his service. Then action of the competent authority cannot be castigated as punitive. However, if the allegation of misconduct constitutes the foundation of the action taken, the ultimate decision taken by the competent authority can be nullified on the ground of violation of rules of natural justice. Then my lord will kindly come to para 35, 36. Or para 35 also, my lord, at page 633. The primary object of confirmation test held on 27-11, which could also be termed as evaluation test within the meaning of para so and so, was to decide whether the officer has made use of the opportunities made available to him bank by bank to prove his worth for the job for which he was recruited, and whether he has acquired sufficient knowledge about the functional requirement of the bank. The test also gave an opportunity to the probationary officer to demonstrate that he was meritorious enough to be placed in a higher grade. There is a marked distinction between concept of satisfactory completion of probation and successful passing of the training test held or during or the end of the period of probation. Which are sine qua non for confirmation of a probationer and bank service to the punish a probationer for any defined misconduct and misbehavior or misdemeanor. In a given case, the competent authority may, while deciding the issue of suitability of a probationer to be confirmed, ignore the acts of misconduct and terminate his service without castigating any aspersion or stigma which may have adversely affect his future prospect. But if the misconduct, misdemeanor constitute the basis of the final decision taken by the competent authority to dispense with the service of the probationer, albeit any by a non-stigmatic order, the court can still lift the veil and declare that in the garb of termination simpliciter, the employer has punished the employer for an act of misconduct. The use of unfair means in the evaluation test, confirmation test held by the bank certainly constitutes a misconduct. Can you excuse me? Sure, sure. Yeah. I had a bout of my lord cough and cold. These are all after effect. We're finishing. I'm also carrying. Thank you. The same thing I'm having.
You got the remedy.
It's a reverse case.
From that side.
The bank itself had treated.
He got a citation rather. Yes.
The use of unfair means in evaluation test, confirmation test held by the bank certainly constitutes a misconduct. Bank itself had treated such an act to be misconduct. it is not in dispute that services of the private respondents were not terminated on the ground that there was any deficiency or shortcomings in their work or performance during the probation, or that they had failed to satisfactorily complete the training, or had failed to secure the qualifying marks in the test. As a matter of fact, the note prepared by the Deputy GM as a matter of fact, the note prepared by the Deputy General Manager, which was approved by the General Manager, makes it clear that decision to dispense with the service of the private respondent was taken solely on the ground.
You can ask your associate to read the judgment. Take a break in the meeting. Yes.
I'm reading para 37.
Yes, Kiran.
The use of unfair means in the evaluation of test confirmation test held by the bank certainly constitutes a misconduct. The bank itself had treated such an act to be a misconduct, para 10 of the advertisement dated 1/7/2008. It is not in dispute that the services of the private respondents were not terminated on the ground that there was any deficiency or shortcoming in their work or performance during probation, or that they had failed to satisfactorily complete the training, or had failed to secure the qualifying marks in the test held on 27/2/2011. As a matter of fact, the note prepared by the Deputy General Manager, which was approved by the General Manager, makes it crystal clear that the decision to dispense with the services of the private respondents was taken solely on the ground that they were guilty of using unfair means in the test held on 27/2/2011. To put it differently, the foundation of the action taken by the General Manager was the accusation that while appearing in the objective test, the private respondents had restored to copying. IBPS had relied upon the analysis made by the computer and sent a report to the bank that 18 candidates were suspected to have used unfair means. The authority concerned then sent for the chart of sitting arrangement and treated the same as a piece of evidence for coming to the conclusion that the private respondents had indeed used unfair means in the examination. This exercise was not preceded by any inquiry involving the private respondents, and no opportunity was given to them to defend themselves against the charge of use of unfair means. In other words, they were condemned unheard, which in our considered view was legally impermissible. Next, my lord, I will refer to paragraph 38, my lord.
Yes.
And 45, paragraph 38. Before concluding, we may notice the judgments relied upon by the learned senior counsel for the appellants. In Ajit Singh versus State of Punjab, this court considered the question whether the decision of the state government to terminate the services of the appellants who were appointed as executive officers on probation of 1 year could be nullified on the ground of violation of Articles 14 and 16 of the Constitution. The facts of the case show that the Punjab Town Improvement Act 1922 was enacted to make provisions for improvement and expansion of towns in Punjab. The act envisages the creation and constitution of trust, and the trust so created will have a cooperative personality with the perpetual succession and a common seal. The duties and functions of the trust inter alia include preparing of schemes under the Act for various purposes. Section 17 conferred power on the state government to constitute certain services in the manner therein prescribed. One such service contemplated by the section was Punjab Service of Trust Executive Officers. Subsection 2 of Section 17 conferred power on the state government to make rules for regulating the recruitment
and the conditions of service of members of the trust services constituted by the state government. Armed with this power, the state government constituted Punjab Service of Trust executive officers. In exercise of the power conferred by Section 73, read with Section 17(2) of the Act, the state government framed rules styled as Punjab Trust Services Recruitment and Conditions of Service Rules 1978. Rule 521 inter alia provided that 50% of the vacancies in the cadre of executive officers shall be filled up by direct recruitment, and for this purpose, Rule 54 envisages the setting up of a selection committee called the Punjab Trust Services Selection Committee. In 1978, the Directorate of Local Government, Punjab, issued advertisement number so-and-so, inviting applications for the post of classes 1, 2, and 3 of the Trust executive officers. Pursuant to this advertisement, large numbers of persons applied for various posts. The Punjab Trust Services Selection Committee interviewed various candidates and ultimately recommended 11 persons for the post of Trust executive officers. Ajit Singh and Rajinder Singh were recommended for Class 1 post, and S. Swarup Singh and R.L. Bhagavat were recommended for Class 2 post of the Trust executive officers, and the remaining 7 petitioners in this group of petitions were recommended for Class 3 post of the Trust executive officers. These recommendations were accepted and appointment orders were issued by the Punjab government on 28/5/1979. After each appointee completed 1 year of service, an increment was released in his favor. After 1 year, the state government terminated their service by order dated 25/9/1980. Now, Lordship will kindly come to paragraph 45, my lord. The proposition laid down in none of the 5 judgments relied upon by the learned counsel for the appellants is of any assistance to their cause, which were decided on their own facts. We may also add that the abstract proposition laid down in para 29 in so-and-so versus so-and-so is not only contrary to Constitution bench judgment in Shamsher Singh versus State of Punjab, but a large number of other judgments like State of Bihar versus Shiv Vikshuk Mishra, Gujarat Steel Tubes versus Mazdoor Singh Sabha, and Anup Jaswal versus Government of India, to which reference has been made by us and to which attention of the 2-judge bench does not appear to have been drawn. Therefore, the said proposition must be read as confined to the facts of that case and cannot be relied upon for taking the view that a simple order of termination of service can never be declared as punitive, even though it may be founded on serious allegation of misconduct or misdemeanor on the part of the employee.
Well, our next judgment is 2015, 15 SCC 151. 2015, Ratnesh Kumar Chaudhary.
Hmm.
15 SCC 151. My lord will kindly come to paragraph 2. As the facts would expose it, the appellant received the letter of appointment for the post of chest therapist on 14/1/99, which mentioned that he had been selected for appointment to the sanctioned post of chest therapist and would be on probation for a period of 2 years, which could be extended at the discretion of the director of the institute. It also contained a condition that service could be put to an end at any time by the giving 1 month's notice by the other side. It also stipulated certain aspects which pertain to giving a notice and in lieu of notice payment or deposit certain amount as the case may be. The appellant joined the post on 28/99. When the appellant was continuing the post of chest therapist, a complaint was received by Vigilance Department, Government of Bihar on 3/11/2004 relating to illegal appointment of the appointment on the post of chest therapist. The complaint contained that the advertisement for physiotherapists and chest therapists were different because different streams, because the streams are different and the appointment of the appellant was absolutely illegal. In persons of the said complaint, an inquiry was conducted by the Deputy Superintendent of Police, who submitted a report on 3/11/04 to the Deputy Inspector General of Police, Bihar, Patna. Reports reflected on various aspects and pointed out that the appointment was illegal. On the basis of the said report, the Joint Secretary in the Department of Health, by order dated 9/3/2005, requested Director so-and-so to initiate a proceeding for termination of service of the appellant by giving a show cause notice. On the basis of the said communication, the appellant was asked by the Director to show cause within 3 days as to why, on account of illegal appointment, his services should not be terminated. The petitioner sent his reply on 23/05 and asked for a copy of the complaint as well as the entire report submitted by Vigilance Department. Despite the request made by the appellant, all the documents are not supplied to him, which the appellant considered vital. However, he submitted a reply on 8/4/2005 and 9/4/2005. Director terminated his service by stating that his appointment on the post of so-and-so was illegal in terms of the investigation done by the Cabinet Vigilance, and the explanation furnished by him in pursuance of the show cause had been found unsatisfactory. Taking exception to the aforesaid order of termination, the appellant invoked the jurisdiction of the High Court of Judicature in Patna. The learned single judge by order dated quashed the order of termination and directed appellant should be treated in service with consequential benefit. The learned single judge, as is evident, quashed the order on the bedrock that appellant was all through kept in dark and as to on what ground his services has been terminated. And further, he was not furnished with necessary documents which form part of the inquiry conducted by the Cabinet. The learned single judge opined that there has been a violation of principle of natural justice in view of the allegation against the petitioner. Being dissatisfied with the order of the learned single judge, the institute and its board governors preferred LPA number so-and-so appropriate to reproduce certain paragraphs. So appeal was disposed of. Eventually matter went to Supreme Court. Now my lord will kindly come to paragraph 15. My lord, from paragraph 15 to 24, my lord, different authorities were referred to. Then my lord will kindly come to para 25, 26, and 27. At page 166.
Yes.
In Palak Modi, the ratio that has been laid down by the two judges bench is to the following effect.
That you already read.
Yes. Then my lord will kindly see para 26. In the facts of Palak Modi, the court proceeded to state that there is a marked distinction between a concept of satisfactory completion of probation and successful passing of training tests held during or at the end of the period of probation, which are sine qua non for confirmation of the probationer, and bank's right to punish a probationer for any defined misconduct, misbehavior, or misdemeanor. In a given case, the competent authority may, while deciding the issue of suitability of the probationer to be confirmed, ignore the acts of misconduct and terminate his service without casting any aspersion or stigma, which may adversely affect his future prospect. But if misconduct, misdemeanor constitutes the basis of the final decision taken by the competent authority to dispense with the service of the probationer, albeit by a non-stigmatic order, the court can lift the veil and declare that in the garb of termination simpliciter, the employer has been punished by the employee for an act of misconduct. In the case in hand, it is clear as crystal that on the basis of a complaint made by a member of the Legislative Assembly, an inquiry was directed to be held. It has been innocuously stated that the complaint was relating to illegal selection on the ground that the appellant did not possess requisite qualification and was appointed to the post of chest therapist. The report that was submitted by the Cabinet Vigilance Department eloquently states about the conduct and character of the appellant. Stand taken in the counter affidavit indicates about behavior of the appellant. It is also noticeable that the authorities, after issuing notice to show cause and obtaining a reply from the delinquent, did not supply the documents. Be that as it may, no regular inquiry was held and he was visited with punishment of dismissal. It is well settled in law, if an ex parte inquiry is held behind the back of the delinquent employee, and there are stigmatic remarks, and that would constitute foundation and not motive. Therefore, when the inquiry commenced, and thereafter, without framing any charge or without holding an inquiry, the delinquent employee was dismissed, definitely there is a clear violation of the principles of nature and justice. It cannot be equated with a situation of dropping the disciplinary proceeding and passing an order of termination simplicity. In that event, it would have been a motive, and that could have traveled to the realm of foundation. We may hasten to add that the appellant would have been visited with minor punishment. The matter possibly could have been totally different. This is not the case. It is not the case that he was terminated solely on the ground of earlier punishment. In fact, he continued in service thereafter. As the report would reflect that there are many an allegations subsequent to the imposition of punishment relating to his conduct, misbehavior, and disobedience. The Vigilance Department, in fact, had conducted an inquiry behind the back of the appellant. The stigma has been cast in view of the report received by the Central Vigilance Commission, his ex-party. And when he was put to delinquent employee, holding a regular inquiry is imperative. It was not an inquiry only to find out that he did not possess the requisite qualification. Had that been so, the matter would have been altogether different. The allegations in the report of the vigilance pertain to his misbehavior, conduct, and his dealing with officers, and the same also gets accentuated by the stand taken in the counter affidavit. Thus, by no stretch of imagination can it be accepted that it was a termination simpliciter. The division bench has expressed the view that no department inquiry is required to be held. It was only an inquiry to find out necessary qualifications for the post of chest therapist. Had the factual score been so, the said analysis would have been treated as correct. But unfortunately, the exposition of factual matrix is absolutely different. Under such circumstances, it is extremely difficult to concur with the view expressed by the division bench. The learned single judge in our case has taken the view that we could not place any judgment which refers to conduct before recruitment. These are the old cases.
This judgment clearly deals with selection conduct. In that event, inquiry has been held to be mandatory. But there is an observation. Come to Placitum C. It was not an inquiry only to holding of a regular and find out whether he did not possess the requisite qualification. Had that been so, the matter would have been altogether different. So this case is covered by that observation.
My lord will kindly
inquiry to find out qualification. That would also include an inquiry to find out whether the selection was procured by fraud. If that is so, what is the scope of giving an opportunity?
I'm replying, my lord.
Yes.
In fact, precisely coming to Placidum C, my lord.
Yes.
Now there could be two possibilities. In the process of evaluating the performance of a probationer to find out whether it is suitable to be retained, that could be one type of inquiry. In such an inquiry, my lord, supposing some misconduct or something wrong attributable to the holder of the post comes to light, but authority chooses no, will not ignore this, but at the same time will not retain him, then it will still be a termination simplicity.
Yes, that's right.
But in a case, my lord, where the exercise was not to find out whether I'm suitable for retention, the exercise was to find out my fault, be it recruitment, be it my post-recruitment conduct. In such a case, whether either Article 311 or principles of natural justice will apply or not. That, in my humble submission, is the issue which falls for consideration in this case. And going by the preponderance of the judicial view, my lord, where Article 311 is attracted, or my lord, we may say the principles of natural justice. This is one case which shows to my lord. My lord, in other words, if my lord, if the pre-recruitment aspect is to be gone into, then state must bring the case within the fold of a fraud. It's not a case of fraud, my lord. If it is a fraud, then it vitiates everything, including solemn act of the Honorable Court. But this is not a case of that. No, they are relying on a police report. Our submission is, can you rely on this? Because you never undertook an exercise to find whether I'm eligible for retention or continuation in service. In that exercise, if you take note of that my entry into service was wrong, that this and that, then I can appreciate. The records will reveal. Therefore, the records has to be produced. Records must disclose that this was an exercise for what? If the records reveal that they wanted to test me whether I am liable to be, my lord, retained or I am confirmed, in that exercise, if the decision is taken, perhaps, my lord, the state would be right. That is what in Gujarat still choose, my lord. Justice Krishna has said that. But that is not the case here. They conducted the inquiry to find out whether I am guilty of entering in, I am taking illegal appointment. If that is so, my lord, why? How can I be denied the principles of natural justice? And my lord, one more judgment on this point. That is 2005 SCC 152. Chandra Prakash Sahi. My lord, 2005 SCC 152. Two 2005 SCC. 2005 number bolo. My lord, this judgment I am placing for that motive and foundation part, my lord. Please come to para 28 and 29. The important principles which are deducible on the concept of motive and foundation concerning a probationer are that a probationer has no right to hold the post and his service can be terminated at any time during or at the end of the period of probation on account of general unsuitability for the post in question. It is for determination of suitability of the probationer for the post in question or for his further retention in service or for confirmation an inquiry is held, and it is on the basis of that inquiry a decision is taken to terminate his service. The order will not be punitive in nature. But if there are allegations of misconduct or an inquiry is held to find out the truth of that misconduct and an order terminating the service is passed on the basis of that inquiry, the order will be punitive in nature as the inquiry was held not for assessing the general suitability of the employee for the post in question, but to find out the truth of the allegation of misconduct against an employee. In this situation, the order would be founded on misconduct and it will not be a mere matter of motive. But I would like to just add one more aspect, my lord. When we use the expression misconduct, whether it covers my conduct post my recruitment or when I was still an applicant at that stage, whether that my conduct will include that or not. My lord, if we give a very broader meaning, my lord, I think, my lord, this is interchangeable. It can be applied in both the situations. End of the day, my lord, as an employee, I may resort to some activities which may constitute misconduct according to conduct rules. As an applicant, my lord, my misconduct could also include my attempt to get into service illegally. So end of the day, my lord, when you are taking note of misconduct, and that too in an exercise where you are not trying to find out my suitability, in that case, my lord, the moving factor is the foundation. Therefore, it will be, my lord, violative of natural justice. Motive is the moving power which impels action for a definite result. Or to put it differently, motive is that which incites or stimulates a person to do an act. An order terminating the service of an employee is an act done by the employer. What is that factor which impelled the employer to take this action? If it was factor of general unsuitability of the employee for the post held by him, the actions would be upheld in law. If, however, there are allegations of serious misconduct against the employee and the preliminary inquiry is held behind the back to ascertain the truth of those allegations and a termination order is passed thereafter, the order having regard to other circumstances would be founded on the allegations of misconduct which were found to be true in the preliminary inquiry. So, my lord, the moment, my lord, an element of, misconduct, be that the whatever stage we may comprehend, my lord, And in my humble submission, my lord, the preponderance of judicial view seems to be that there is a requirement of giving at least a notice, my lord. In the absence of that notice, then it will be, my lord, bad. My lord, I'll place 2-3 judgments on this point. Let me place that, my lord, Gujarat Steel Tubes case, 1982 SCC 593.
Yes.
My lord, I'll have your lordship's kind attention to para 53. Masters and servant. Masters and servants cannot be permitted to play hide and seek with a view with the law of dismissal, and the plain and proper criteria not to be misdirected by terminologies, cover-ups, or by appeal to psychic process, but must be grounded on substantive reason for the order, whether disclosed or undisclosed. The court will find out from the proceedings or documents connected with the formal order of termination what the true ground for termination is. If thus scrutinized, the order has a punitive flavor, and in cause or consequence, it is dismissal. If it falls short of this test, it cannot be called a punishment. To put it slightly differently, termination effected because master is satisfied of the misconduct and of consequent desirability of terminating the service of the delinquent servant is a dismissal, even if it had the right in law to terminate with an innocent order under the standing order or otherwise. Whether in such a case the grounds are recorded in a different proceeding from the formal order does not detract from its nature, nor the fact that after being satisfied of the guilt, the master abandons the inquiry and proceeds to terminate. Given an alleged misconduct and a live nexus between it and the termination of service, the conclusion is dismissal, even if full benefits, as on a simple termination, are given and injurious terminology is used. Non-injurious terminology is used. So, my lord,
This deals with provisions of the industrial disputes.
of course, but my lord, this passage has been, referred to in all the subsequent cases, my lord.
It's okay.
My lord, the proposition is, my lord, that the moment you take note of a misconduct, then even if you use non-injurious terminology, it will still be a punitive.
What is punitive?
Stigmatic. Yes. My lord, that judgment of one judgment, my lord, on my lord, this in judgment in my humble submission is very important, my lord. This is something on Article 16, that manager, government press, and another versus Beliappa, 1979, 1 SCC 477. It is on protection from Article 16, my lord. My lord, the page is 477.
Yes, please.
I'll have your lordship's kind attention to 2 paragraphs, paragraph 18 and 19 at page 483.
Yes.
Mr. Virappa's first contention is that Article 14 and 16(1) of the Constitution have no application whatsoever to the case of a temporary employee whose service is terminated in accordance with the terms and conditions of his service, because the tenure or duration of the employment of such employee is extremely precarious, depending upon the pleasure and discretion of the employer state. In our opinion, no such generalization can be made. Protection of Article 14 and 16(1) will be available even to such a temporary government servant if he has been arbitrarily discriminated against and singled out for harsh treatment in preference to juniors similarly circumscribed. It is true that competent authority has a discretion under condition of service governing the employee concerned to terminate the latter's employment without notice. But such discretion has to be exercised in accordance with reason, fair play, and not capriciously. Bereft of the rationality and fairness, discretion degenerates into arbitrariness, which is the very antithesis of the rule of law on which our democratic polity is founded. Arbitrary invocation of enforcement of a service condition terminating the service of a temporary employee may itself constitute denial of equal protection and offend the equality clause in Article 14 and 16(1). Article 16(1) guarantees equality of opportunity for all citizens in matters relating to employment or appointment or to any office under the state. Moreover, according to the principles underlying the Section 16 of the General Clause Act, expression appointment used in Article 16(1) will include termination or removal of service also. It is now well settled that the expression matters relating to employment used in Article 16(1) is not confined to initial matters prior to the act of employment, but comprehends all matters in relation to employment, both prior and subsequent to the employment, which are incidental to the employment and form part of the terms and conditions of such employment, and such as provision as to salary, increment, leave, gratuity, pension, age of suspension, superannuation, promotion, and even termination from employment. It is further well established that Article 14, 15(1), and 16(1) form part of the same constitutional code of guarantee and supplement each other. If any authority is needed for the above enunciation, reference may be made to sense. So, my lord, when it comes to
So this principle has been further crystallized
yes,
by in various judgments saying that one set of contractual employees cannot be replaced by another.
set of
The same principle.
yes, ma'am.
Article 16 applies even there.
Yes, ma'am. So it cannot be confined to only one stage, it across these stages. My lord, next is the 1984 2 SCC 369.
Yes.
1984 2 SCC 369, paragraph 11, 12, and 13.
Yes, please.
On behalf of the Union of India, reliance has been placed on the state of Punjab versus so and so, so and so, so and so. We have gone through these decisions, except the case of Ramchandra Trivedi. All other cases referred to the above were decided prior to the decision in Shamsher Singh, which is a judgment delivered by a bench of 7 judges. As pointed out by us in all these cases, including the case of Ramchandra Trivedi, the principle applies the one enunciated in Purushottam Lal Dhingra, which have been referred to earlier. It is ours relying upon the observation in Sukhraj Bahadur that it is only when there is a full-scale departmental inquiry envisaged by Article 11(2) that an inquiry officer is appointed, charge sheet submitted, explanation called for, and considered. Any termination made thereafter will attract Article 11(2). It is significant that in the same very decision it is stated that circumstances preceding or attending on the order of termination of the service have to be examined in each case, motive behind it being immaterial. As observed by Ray CJ in Shamsher Singh, the form of the order is not decisive as to whether order is by a punishment or even innocuously worded order terminating. The service may in fact and circumstances of the case establish the inquiry into allegation of serious and grave character of misconduct involving stigma has been made in infraction of provision of Article 311(2). It is therefore well settled that where form of the order is merely camouflaging or an order of dismissal for misconduct, it is always open to the court before which the order is challenged to go behind the form, ascertain the true character of the order. If the court holds that the order though in form is merely a determination of employment is in reality a cloak for an order of punishment. Court would not be debarred merely because of form of the order in giving effect to the rights conferred by law upon the employee. In the instant case, the period of probation had not yet been over. The impune order of discharge was passed in the middle of the probationary period. An explanation was called from
This is the
applicant.
case wherein show cause notice was given regarding conduct.
Yes, and this is the.
It's totally a distinguishable case.
So, my lord, last judgment, I will rely upon this Khatri judgment, my lord, regarding, the police, what is the purport of this when, in what situation in a proceeding under Article 32 or 226, my lord, the police report can be relied upon. In 1981, 2 FCC 493. My lord, this arose after that Bhagalpur blinding, my lord. Yes, that famous. My lord, will kindly come to paragraph 9. At page 505.
Yes.
It is clear from the aforesaid discussion that the fact in issue in the inquiry before the court in the present writ petition is whether the petitioners were blinded by members of the police force at the time of the arrest or while in police custody. Now, in order to determine whether the reports made by Sri So-and-so as a result of investigation carried out by him and his associate are relevant, it is necessary to consider whether they have any bearing on the fact in issue required to be decided by the court. It is the common ground that Sri So-and-so was directed by the state government under Section 3 of the Indian Penal Code to investigate it into 24 cases of blinding of under 12 prisoners where the allegations were made by under 12 prisoners and the first information report were lodged at that they were blinded by the police officers while in police custody. Sri So-and-so, through his associate, carried out investigation and submitted his report in the charge of his official duty entrusted to
So
him by
this
the
was a
state government.
case wherein the Supreme Court had directed production of the reports.
Yes.
That was the issue which was under consideration.
No, my lord, it also deals with one more aspect.
Yes.
In a proceeding under Article 226 and 32,
Yes.
when a police report would be relevant.
The Supreme Court has called for those reports. State were resisting.
Yes.
So relevancy or otherwise was to be decided by the court.
Yes,
How
no,
is
but
this judgment?
kindly allow me to read this, only this paragraph.
Very
Yes. These reports clearly relate to issue as to how, in what manner, and by whom the 24 under trial prisoners were blinded. For that, it is a matter which Singh has directed by the state government. If that be so, it is difficult to see how the state can resist the production of these reports
in the present
and their
proceeding.
use as an evidence in the present
Mr.
proceeding.
Chaudhary, the law is
The report,
settled.
yes,
The court, High Court, for that matter,
Supreme
having
Court.
inherent powers under 482, can always direct production of a case in
Yes.
any proceeding before it.
Yes.
So there's,
Now, my lord, what I'm trying to say is, my lord,
yes,
my first submission is, my lord, that police report per se could not have formed the basis.
it's
Now,
not substantive material as per you.
Yes, my lord, because at this stage when the satisfaction is recorded, it will be subjective. There's no doubt about it. But the materials must be objective. In other words, my lord, it must be material which must inspire confidence of the court.
Very well.
So, my lord, per se, it could not have been taken note. Now, therefore, my lord, to sum up my argument, my lord,
Yes.
we are probationers. While we are in service, while we have completed all the trainings and all, a police case was registered, pursuant to which, my lord, we were arrested, we were in detention, we were placed under suspension. Subsequently, my lord, we were discharged, and which were challenged before the learned single judge, which has been dismissed by the learned single judge. Now, the question is, we are assailing the decision-making process. For a moment, my lord, it is not our case that there are manner in which the decision could have been taken against us, which could have tested, inspired your lordship's confidence. But the manner in which, in the present case, my lord, our rights have been dealt with all respect, I'll submit, my lord, this was improper. We were entitled to it. You are relying on materials which were collected behind us. My lord, at the stage of investigation, my lord, we are not a party. So, my lord, you are relying on those materials. Are we not entitled to a notice? Hold an inquiry, hold an administrative inquiry, as was done in the case of my lord Punjab case. Then take actions. Nobody is questioning your wisdom or authority. But the manner in which it has been done, and that too, my lord, they have come up in the stand in para 7.
Anything to suggest that the inquiry which was conducted in the Punjab cases were bipartite inquiries. Were bipartite inquiries.
My lord, the lordship, this is not evident very clearly.
They were in-house inquiries, all fact-finding inquiries under the directions of the
Not very
court.
clearly evident, my lord.
It is
I'm sorry.
under the directions of the court. So not an inquiry in the sense of a department inquiry.
So at least, my lord, to give legitimacy to the action, at least it was backed by my report of the 3 honorable judges of the High Court. Here, my lord, they could have appointed one of the personal department, the secretary, to conduct an inquiry. Then they could have taken.
Why don't we have a faith in our own police system? The report of a police officer being a public servant.
No, it's not a question of not having faith.
Then
it's a question of what weightage those materials can be given in a proceeding.
Okay, very well.
So therefore, my lord, in my humble submission, my lord, it's a case where, my lord, the power has been exercised for unauthorized purpose. Therefore, my lord, it cannot withstand judicial scrutiny.
Thank you.
My lord, I'm also appearing in the APS cases. There are little distinction. Let me place those, my lord.
APS. This was a case of
ACS.
This was in ACS, my lord. I'll give the numbers, my lord.
So what is the distinction? What is the distinction basically?
Yes, distinction is, my lord, here the probation was complete. In case of the police officers.
Probation was complete and they were confirmed in service.
Not confirmed.
So
the order of confirmation was not there, but I'll project this.
So
Only
simply
that's the
because
only
the period was complete, whether there's a presumption that they would be confirmed.
My lord, of course,
It can be extended. Probation period is always extended.
Now, of course, it is said, my lord, that there has to be a formal order.
Specific formal order has to be there. So,
but then, my lord,
not there. The employee would be continuing as
I'll refer to one document to show, my lord, 2-3 documents to show. If your lordship, item number, my lord will kindly have item 25. The heavy order to court. One post suspending order discharge equity quantity.
Yes.
My lord will kindly come to page number 48, my lord.
48.
Yes. Sorry, my lord, 46. These are in case of the Assam Police Service officers.
846 of
the memo of appeal. My lord, by this order, posting orders were given to different Assam Police Service officers. Now, if your lordship kindly comes to page 48 towards the bottom.
40?
Page 48. Last para towards the bottom. The above posting of APS junior grade 2015 batch have completed probationary period of 2 years and are exempted from mandatory posting in battalion for a period of 4 months. as per OMDT so and so, as the services are urgently required in the field and in the specialized agencies, that is CID, Border, Vigilance and Anti-Corruption, CM Vigilance, STF, SB, due to shortage of
For a
officers.
specific purpose, this observation was made. To post them in the field.
Now, my lord, will kindly come to page 49.
49.
Yes.
Mm.
Now, this was the order passed in 2017, when, my lord, I was given a posting. With reference to Rule 145 of the Assam Financial Rule, I, the undersigned, have honor to report that I have this 17 October handed over received charge of Deputy Superintendent of Police Probationer, at 19 so and so, White so and so, so and so. So, my lord, when I was given this posting and then when I took over
Joint, still you are
I
referred to
was
as,
described as a provisioner.
as a probationer.
Yes.
Yes. Then,
Now kindly come to page 50.
Mr. Chaudhary, would you deny the proposition that there has to be a specific order of confirmation?
I can't say no, my lord.
And because in Rajasthan, it makes a whole lot of difference. Because the probational draws a fixed salary. And he gets regular salary only after confirmation.
Achha.
So
Anyway, my lord,
having
I'm
a
just
formal
showing-
order of
I'm
confirmation
just
is,
showing the understanding of the government. my lord.
yes, therein the word probationer is missing.
That is after that order.
Yes.
With reference to rule so and so, I understand, have honor to report that I have on so and so handed over, received charge of Deputy Superintendent of Police Tengakhat, so and so, so and so. That, my lord, is not there.
Okay.
So I got a charge posting. Now, my lord, in case of Assam Police Service, my lord, the rule is different. Otherwise, my lord, same proposition, same everything. Here, my lord, rule 16B,
There it was, rule 20.
20C.
20C. But there is a catch, my lord. Kindly see, my lord, rule
Yes,
16B.
just a moment. 16.
B at
B.
page 223. A probationer shall be liable to be discharged from service, or in the case of persons appointed to service under clause so and so, be reverted to the post of Inspector of Police if he B is considered unsuitable for reasons to be recorded for continuing in service. That means, my lord, the exercise has to be specifically undertaken whether I am suitable or unsuitable. Now that must be evident from the record. Otherwise, my lord, the whole thing goes.
Very well.
Apart from the other arguments. At least in case of ACS officers, my lord, there is some leeway. Here, my lord, they cannot say. Because they have invoked a provision where they have proposed, as they professed, that an exercise was undertaken, and in that exercise, we are not found suitable.
Whether this specific argument was raised
Yes, yes, my lord.
and how it was dealt with.
My lord, this aspect has not been dealt with.
Is the argument
In
noted?
fact, my lord, yes, my lord. In fact, I filed a written argument. If your lordship would kindly come to in this memo of appeal, page 212, my entire written argument is annexed.
Very well. We'll check.
Filed before the learned single judge.
Yes.
So, my lord, these are the distinguishing features as far as. And my lord, in this, there was an interim order also whereby the order of discharge was stayed. I'll just have your lordship's kind attention to that at page 146.
146.
Yes.
One post was
146.
ordered to be reserved. But your,
No, but one post means in this particular case, same order was continuing.
but then your service was not protected.
Service was not. No. No, my lord, there is one observation. Please come to page 150, my lord. Para 5. Mr. R.K.D. Chaudhary, learned additional senior government advocate Assam, has accordingly produced the relevant file today. Dealing with the issuance of the aforesaid discharge order, the court has gone to the said file. Relevant parts of that file indicate that the authorities relied on investigation undertaken by the police in connection with the related criminal case to come to the conclusion that petitioner had secured appointment by engaging in fraudulent act by replacing the answer script in connivance with the then chairman of the Public Service Commission. However, on queried by this court, it has been clarified by the learned senior government advocate that finding of the police is based on the charge sheet being submitted before the criminal court.
Already we have read the order, but
Yes.
whether it was continued further,
Yes. no,
because the
yes,
order was
until it was decided.
limited till next date only.
Yes.
Okay,
No,
so
my lord, just
order,
one more fact, Lordship, can you permit me? In other words, aforesaid finding of fraudulent activity alleged to have been committed by the petitioner.
this is now merged in the final order, Mr. These findings.
It is my-
They have merged in the final order, but whether the appellant continued in service after that,
Yes.
because the order was suspended.
Yes,
Okay.
subsistence allowance were given, my lord.
Because she was under
Yes,
suspension.
so these are the distinction, my lord, as far as factual part between this. That is my humble submission. So I reserve my right of reply, subject to what my learned friend. Mr.
Rejoinder. Rejoinder. Reply he will be giving. Yes. Yes.
My lord, I appear in two other matter. In one it is labor service and other is, my lord, what my junior will give, make a slip, my lord, give the number. I deeply obliged. And my friend, Mr. Mishra is there, my lord. Oh, my elder brother is also there.
My lord, I am appearing in item number 20. With hardly 15 minutes left, today, my lord, I will just draw your lordship's attention to some distinction in my case, my lord. Number one.
Your client is in which service, was in which service?
Yes.
ACS.
My lord. From me, my lord, there was no statement either under 161 or 164 CRPC. Unlike many others of this batch of petitioners. Paragraph 48 of the, my lord, learned single judge's judgment at page 324, I'll refer to straight away. Take my file, my lord. This is WPC, writ appeal 75.
Paragraph.
It is, my lord, page 324, my lord.
Paragraph.
Running page, yes.
Paragraph.
Paragraph I am coming. 48 of the judgment, my lord.
Was your client arrested or not?
Arrested, my lord.
No, let read.
Yes. Before the Dibrugarh Para 48, Dibrugarh Police. Following investigations are part of the record and a compilation of the same has also been furnished before this court by so-and-so learned senior counsel during the course of hearing. It seemed that the illegalities, irregularities discovered in this election had been scrutinized, investigated upon in respect of each of the writ petitioners, detailed police investigations enabled to pick up the candidates who had unlawfully benefited. A mere perusal of the police reports leaves no room for doubt as to the thoroughness with which investigation was carried out. Irregularities attributed against each of the petitioners are minuted, my lord, reinforced by statement made before investigating officer by such petitioners as available in the records admitting to their complicity. Having gone through the police reports, the prima facie view of the court is that the same comments itself to acceptance. Now, my lord, there is a blatant, my lord, roping in. Lordship, I will take your lordship to page 319.
Yes.
Running page, my lord, it is in paragraph 43.
Applying above principle present cases to ascertain circumstances and the foundational facts leading to discharge of the petitioners from service during probation, official record files containing the notes on arrest and suspension of petitioners as well as the notes on the decision-making process involving consultations with the approval accorded by the high government authorities are perused. The office files, it starts from here, my lord. The office files called for by this court covers each of the 52 writ petitioners, and to be precise, the following office files. Now it gives the office files and also the code numbers of every delinquent.
Individual.
Next page. It ends here. Next page, 320. After the names, the grounds of arrest and the materials collected against the petitioners are contained in the aforesaid office files. Broadly, investigations revealed that petitioners were involved in securing job by adopting unlawful means in collusion with the arrested accused persons, Rakesh Pal, and other arrested members of the APSC officials and agents connected therewith. During the course of investigation, written answer scripts of the APSC combined competitive examination were seized from the confidential examination branch of APSC as well as from the house of Rakesh Pal. The handwriting samples of the arrested accused persons as well as of the petitioners were obtained sent to forensic. It revealed that the answer scripts were not printed in the government press. This is an accusation, my lord. Also, the signatures of invigilators of the answer scripts were found to be fake and mismatched with the invigilators who were on duty on the respective day of examination in the particular hall. These fake answer scripts were written again by the petitioners after completion of the examination, and the same were replaced with the original answer sheets in connivance with Rakesh Pal and his arrested associates. Now, paragraph 44, this is important, and this is precisely what I intend your lordship's notice to bring. Without entering into any legal argument as to the admissibility, which is for the appropriate fora to decide, this office files also contains statements made by a section of the petitioners before the police admitting to their complicity in the illegal activity to which they were beneficiaries. The statements of such petitioners found in the office files are that of, it is very specific, my lord. Names are given and the code number are given. There is one, as your lordship posing here, admissibility as evidence of a statement before police, my lord. That is different, and the golden rule of Miranda, my lord. 1937 Privy Council Nasir Hussain. It is discussed. And even in case of a statement under 164, normally a person is cautioned before recording it. Here, my lord, it refers that these petitioners, these delinquents all gave statement admitting to their complicity before the police. Now, next paragraph 321, it ends, it gives. Importantly, my lord, my code is not here. A22 is my code. So, I was not the one who made a statement under 161. With respect to learned single judge, my lord, he roped in blanket my name to these findings of his. And I'm afraid without any application of mine. And it was error apparent on the face of these findings. And this finding is absolutely without basis.
Has the learned single judge referred to your name in this list?
No.
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 So you argue that your statement was not recorded.
I never gave a
learned single judge also doesn't note that your signature was recorded.
No.
Then
my lord,
what is the error apparent on the face of it?
It has mentioned, my lord, everybody's name who gave a statement before the police admitted to their guilt.
Since you did not give a statement, your name is not referred.
Not.
But in spite thereof, the decision has been taken to uphold your termination. Right?
I was also roped in.
Yes. Okay.
I was roped in without any application of mine.
Okay.
To the materials on record.
Are the statements,
Yes.
do the statements constitute the only material, or there is something else also?
My lord, the statement before police they relied on, my lord, in the police report, and the learned single judge also.
Mr. Borbora, your client did not give a statement, so it was not relied on. But is there any other material referred to in the decision-making process? That is what we are asking you.
I also didn't give any confessional statement before the magistrate under 164. That
other than the so-called confessional statement, is there any additional material which was relied upon in or reaching to the decision?
not against me.
Okay,
In
very well.
particular, not against me.
Okay.
Maybe against other my lord bunches of petitions.
Very well. Okay.
So therefore, and importantly, my code, I am referring it, my lord.
A22.
My code is A22.
Yes.
It is nowhere there, my lord.
Mm.
Now, it was also alleged that the answer scripts were not printed in the government press.
Mm.
Now here, my lord, I want to place a very important, my lord, piece of information. During the pendency, I put it on record by filing an affidavit by me, my lord. Affidavit dated 24/2022. It should be in the file, my lord. Affidavit dated 24/20. As a lawsuit got it.
Mm. Yes.
I have annexed a few documents there, my lord.
Mm.
Okay. Document number 2 at page 6.
Mm.
Some RTI information was sought for
Mm.
by this forwarding letter, my lord. The State Public Information Director of Printing and Stationery
Mm.
has given the reply, which your lordship will find as document number 2,
Mm.
page 7, within bracket capital A. This information was given by State Public Information Officer, Directorate of Printing and Stationery, Assam, Guwahati,
Mm.
to the RTI applicant.
Yes.
Furnishing of information under RTI, petition dated so and so. With reference to the subject cited above, I would like to inform you that no answer script, sheets, khata of combined competitive main examination 2013 conducted by APSC was printed at the Assam government press. Am I clear, my lord? So the allegation is that your answer script was one which was not printed at the government press, state government press. Then, my lord, here, my lord, document number 4 at page 9 also, my lord. This also be a pertinent document.
Mm.
It is 2000, it was issued on, my lord, 25th of November 2021 during the Pensable case.
Mm.
My lord, furnishing information RTI, it is again from, my lord, the State Public Information Officer of Directorate of Printing and Stationery.
Your argument is it's a usual practice not to get it printed from the Assam printing press. Okay.
And here, paragraph
Yes.
2.
Yes.
Roman 2 information. 1, APSC placed last order printing so and so. 2, there is no standing order notification of Government of Assam to print answer script khata of APSC at Assam government press.
Yes.
The directorate print the answer scripts only after receiving any specific order. And the other document, my lord, I referred just now, my lord, it clearly says that for the 2013 exam.
There was no printing from the comment printing press. All right.
So that is one. And then I will come back to, this is the distinction part, my lord. I have shown and the answer scripts, my lord. And my lord, I will argue, my lord. Maybe insinuate, there are others to argue also in the coming days. There are two things, my lord. That you are found to be unsuitable is a different proposition. And because of this misconduct and whatever this demeanor, my lord, you are discharged is
Yes.
different. The stand of the government, my lord, is self-contradictory and self-defeating. If you say fraud in getting selected by and obtaining a job, is that may be in the realm of discharging me, my lord. But at the same time, you just cannot again say that, well, you are unsuitable, therefore we are discharging you. That is also stigmatic. as opposed to, my lord, ineligibility. And it is not an ingredient under the relevant rule 20C, clause C, my lord.
Yes.
And one thing about natural justice, I endorse what Chaudhary said, submitted all the way before your lordship, my lord. Natural justice is required because it is not a case. There are cases, my lord, where Supreme Court directed the concerned, my lord, examination holding authorities to go for a de novo examinations for all and sundry. It is not like a case where the entire process of selection is cancelled or abandoned. In that case, no one is entitled to, my lord, natural justice. It is a case where some people were picked up for the, at least, my lord, misdemeanor offenses, my lord, illegalities, getting jobs. There is forgery also, it is easier said than proved. With means of, my lord, suppose there is mass copying in an examination, a number of courses, my lord, I'll cite when my turn comes. Mass copying, everybody might not have been copying. In an examination center, out of 200 candidates, maybe 60 were mass copying, but on detection, the entire examination is set aside and directed to be held de novo. This is not a case. Here, I will, my lord, submit that the government went for some picking and choosing.
Oh.
So I think, my lord, today it will not be possible.
Arguments heard in part. Hearing to continue, list
Lordship.
Lordship will be fixing a date for the.
Tomorrow.
I'll
Once
appear-
the arguments commence,
Of course, I'll join by
no
VC with
question.
Lordship's permission.
That's your convenience.
I'm so.
Once the arguments commence,
Of course, Lordship.
there's
That's how
no break except for a holiday.
I'll be there to assist, Lord.
Sir, item number 2, my lord, your lordship has passed over for the timing. Let it come on Tuesday next time.
Next Tuesday.
Okay.
All right.